Boom. Hey, folks, how's everyone doing? I hope everyone's having a wonderful afternoon. Um, I've got a cola here, and so if you happen to see like liquid on my face as I'm streaming, I just want to let you know that is because I am coming to you live from Satan's armpit. Muted? What do you mean muted? Um, I see that I've got audio. Are you guys hearing me? Um, okay. People say they see audio. Okay, cool. Oh, I apparently came in mid sentence. Did you guys not hear the fuse? All right, then I guess I owe you a boom. All right. So, what is the news? Well, we covered this earlier today, so some of you may have already seen this, and if you have, you are welcome to stick around, or you're welcome to step out. I see people say no fuse. Okay, StreamYard is extremely acting up lately. StreamYard is doing some things, so we're gonna try to fight with it as best we can. Is what it is. All right, so what is the latest news? Well, during the Rust trial with Alec Baldwin, we saw that there were some evidentiary shenanigans. And those evidentiary shenanigans included that basically they'd failed to turn over information about certain live bullets that were provided by a friend of Thel Reed, and that those were not turned over to the Baldwin defense. And because of that, the case was thrown out. It was dismissed with prejudice, so the case is over, the case is done, everything is finished, and that's it. So now I predicted when we saw that, I said, oh, Bowles is at his computer right now writing down, he's writing up a motion for a new trial. That's what he's doing, right? He's hard at work, and that we're going to get this Monday because basically for Bowles, this is going to be a drop everything and file this first thing Monday morning. Well, I was wrong about part of it because he didn't file it first thing Monday morning. He filed it last thing close of business on Monday because it came in at the wonderful time of 3:19 p.m. That's when the filing time is on this. So Bowles could have got that in a little sooner, but you know what? Fair enough. He needed the extra day, so yeah. Didn't I review this earlier? Yes, we did. I'm trying an experiment where we're reviewing it earlier in the day to allow people to catch it while at work, and then later in the day for anybody else. This is an experiment. We'll see how it goes. If you like this, let me know. Let me know and via super chats would be, also is sort of a metric that's being used here. But it's an experiment, right? It is purely just a thing to see if this is helpful, because sometimes there's people in different time zones. Sometimes there's people who just are like, I want to see this again. And that's fair. We got Aussies who are like, yeah, I just want to see it later again. All right. So let's have a look at this one. As I mentioned, we're just going to pull this up on the screen. Here we go. As I mentioned, we're just going to do that. It was filed at 3:19 p.m. So just before the close of business. That's why we couldn't go over it on Monday, because it wasn't put up on the online until afterwards. So what is this? This is Hannah Guitierrez Reed's expedited motion for a new trial or for dismissal for discovery violations and under the court's inherent power. Now, he says or for dismissal, but I can tell you there's not actually a lot of argument in here for dismissal. He's mostly asking for a new trial, and yeah. So that is kind of a that's kind of a thing there. So all right, let's have a look there. Katie Harvey says, Runkle, I steal your jokes on the daily and pass them off on my own. Here's a gift in exchange for that and for the pro bono. Cheers from Grand Bend. You are encouraged to do that. You are more than welcome to steal the jokes. That is that's perfectly fine. So, although maybe tell them if you want, you can tell them where you got the jokes, and then maybe they'll pop in the chat. Ella, thank you for the 5 gifted memberships. Mark, something wouldn't trade dreams with you. I'm having deja vu, so have another $5. Thank you so much. Rainman YYC, missed the morning due to therapy. Having a second stream is awesome. Thank you so much. All right, let us roll here. What do I think the chances of awarding a new trial? About 75%. We'll talk about that. So let us talk about this. So Hannah Guitierrez reads expedited motion for new trial. Defendant Hannah Guitierrez Reed, by and through her counsel of record, Jason Bowles, and Monica L. Barreras, respectfully moves this court for a new trial or for dismissal for severe and ongoing discovery violations by the state. This motion is made pursuant to Rule 5614 of the Rules of Criminal Procedure, case law, and the court's inherent powers. So we're going to see some of this, and we're going to see that there's a little bit of issues here. And there's issues on both sides. There's issues both with what Ms. Morrissey did and with Bowles. And we're going to talk about both of those things. I don't think Bowles should be the one arguing this. I think Bowles needs to get another lawyer to argue this. And maybe it's Monica L. Barreras. Maybe she's the one who needs to do it. But maybe it should be just someone else. Is there anybody that owes Bowles a favor who could step in? So, yeah. This is an issue. L. Fliggins, we'll talk about that a bit as well, because there's a problem in that he did sit on a lot of his evidence. So we're going to talk about that. So Baldwin's trial exposes extreme misconduct. Special Prosecutor Morrissey lies to this court under oath. In a hearing on July 12th, 2024, in Mr. Baldwin's case, Ms. Morrissey took the stand, calling herself as a witness, and lied to this court several times. Corporal Hancock testified that Ms. Morrissey was in on the decision to file the Teskey rounds in a separate file. On direct examination, however, Ms. Morrissey stated she never knew it would have a separate file number. Now, here's the thing. I don't know that I would say, I don't know that I would necessarily say that was Ms. Morrissey lying, because there's another potential here. The other potential is that Hancock lied. And certainly, if I'm running a new trial for Hannah, if I'm running a new trial for Hannah Guitierrez, I want it much more to be that Hancock was lying, because she's the lead investigator, than Ms. Morrissey was lying. So I would actually be kind of leaning towards Corporal Hancock lied if I was filing this, right? On direct examination, however, Ms. Morrissey stated she never knew it would have a separate file number. Ms. Morrissey alleged in response to cross-examination that Erlinda Johnson had resigned that day because Ms. Johnson didn't want a public hearing on the Brady violations. This was false. In a media interview on the same day, Ms. Johnson explained that she resigned because of her ethical duties as a prosecutor, and that she had argued that the case should be dismissed by the state because of the late disclosure, and that she was overruled, obviously, by Ms. Morrissey, which sounds to me like she didn't want the public hearing on the matter, right? It was very clear to me that Ms. Morrissey, going into that hearing on the matter, she wasn't going into that hearing on the assumption that the case was going to hold up, right? She wasn't going into that hearing saying, I think, she didn't even make submissions that the case shouldn't be thrown out, right? She didn't make submissions on that. I think that the two have a very different framing of what happened, but I don't think either of them were exactly lying. And I don't think either of them were exactly telling the truth, if that makes sense. So, yeah. But they cite C. Baldwin, prosecutor on resigning, Erlinda Johnson interview with Chris Cuomo, available on X, Twitter. This is not how you cite something, by the way. If you want to cite something, you should cite it specifically with like a direct address. Like, here is where you find it, not available on X. You need to show the actual thing, right? You need to show the actual. This is sloppy. Bowles should know better about how to cite things. You can't just cite to available somewhere on Twitter. So Ms. Morrissey instead decided to plow ahead in her continued win-at-all-costs attitude in the Rust cases. Second, Ms. Morrissey represented in response to questioning that she asked her prior paralegal to resign. That was factually untrue. The paralegal decided to tender his resignation unilaterally after sending several emails to the DA's office about his working conditions and the conduct of Ms. Morrissey that led to his unilateral decision to resign. The paralegal emailed this to undersigned counsel and executed an affidavit. Now, I'm just going to say that affidavit is not attached to this filing, and that affidavit should absolutely have been attached to this filing. But the other thing is, Ms. Morrissey lying at this stage, even if we accept this to be true, which right now it's just allegations, I'm saying if we accept it to be true, isn't actually a big deal for Hannah. This is the wrong place, right? This is the wrong issue. So, yeah. But also, where's your affidavit? Put the affidavit on the freaking filing, sir. Like, you're saying you have an affidavit. That should go on the filing. Bowles, you said he executed an affidavit. Where's the affidavit? I guess he's going to file it later, maybe. But I would put that affidavit on the file, like on this filing. So third, Morrissey represented that undersigned counsel did not want the Teskey rounds and believed they inculpated Ms. Guitierrez-Reed. That is an absolute falsehood. Some background is necessary on this point. The state had been aware and had access to Teskey for years. Seth Kenney called Teskey during a November 1st, 2021 interview with then-Detective Alexandria Hancock, after which Teskey sent a picture of a sampling of ammunition, and the sampling had bronze primers and didn't match the live rounds on set, which had nickel primers. Okay. We know that. There was no further follow-up by the state, even though undersigned counsel texted Detective Hancock asking her to contact Teskey. Detective Hancock also misrepresented at the hearing, saying she called Teskey multiple times with no response. Hancock in text messages told undersigned counsel that she had already talked with Teskey. Yes, I've been present for most of the phone calls and have spoken to him, and also saying, I'm aware, I've seen them, and spoke to Troy. Hancock never again tried to contact him, despite her testimony to this court. Then, in a November 2nd, 2023 pretrial interview of Teskey, the rounds were again discussed, this time with Special Prosecutor Morrissey. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had taken to the 1883 set. Teskey agreed he would preserve it and provide it, and Morrissey indicated he should and that she would work with law enforcement to collect it. Thereafter, Teskey was afraid to do anything with the rounds except preserve them for law enforcement, which he did. The issue that we're having here is that Bowles acknowledges that he knew the rounds existed. Bowles acknowledges that, right? The problem is that Bowles then wants to tell her how to do an investigation. He's like, you need to investigate this, you need to investigate that. And the thing is that the prosecution doesn't, while they have to turn over whatever they have, they don't actually have to do an investigation and get stuff they don't. Bowles could have used the existence of this ammunition. He could absolutely have asked. He could have asked questions about it. He could have all of these things, but he didn't. Like, they were like, why aren't you getting it? And the thing is that Morrissey told him that they weren't going to get it. And he's like, but I need you to. And it's like, well, tough shit. You need to go investigate it if you want to investigate it. So that's the problem he runs into. Morrissey never followed up. The undersigned sent an email to Morrissey on January 8th, 2024, asking if the state was going to retrieve the rounds and test them. Counsel stated in the email that testing was important to compare the powder of the Teskey rounds to the powder in the live rounds found on the Rust set. This had to be done by the FBI through the state, as the FBI had done the original testing and analyzed the powder. Here's the thing. It didn't have to be done by the FBI. It could have been done by an expert hired by Bowles, right? Bowles could have had his own testing. If he'd said, like, hey, you guys still have some of that powder, right? Because they do. They didn't use it all up. We need a sample of the powder because we're getting a hold of these rounds, and our expert is going to do a comparison. They absolutely could have done that. So they should have. And yet they didn't. So that's a problem. Like, saying that it had to be done by the FBI. No, Bowles, you can test stuff. You have that power. You have that ability. You can hire experts to do that. You can all of those things. And so I think Bowles is off base when he says it had to have been done by the FBI, and therefore that creates an obligation. You don't get to dictate the FBI, right? FBI can say, nah, we're not doing it. Undersigned counsel had repeatedly told the state that it needed to test the Teskey rounds and make this comparison. That same day, however, for the first time since November 2nd, Ms. Morrissey emailed back that she did not plan to retrieve or test them because she found them visually dissimilar and not relevant. Okay, so they could have gone to test them, right? Astoundingly, Ms. Morrissey told this court in the July 12th hearing that she'd never seen these rounds until the July 12th during the evidentiary hearing. It was pretty clear what she said was that she had seen a picture sent by the investigators, and that from that picture that she went, oh, they're different, right? The picture sent by the investigator was the picture of those 4 rounds that were dissimilar, and that got her to go, oh, this doesn't matter. It was very clear she did not see the ones that matched, and that's because we have Hancock and Popple who didn't actually provide that information to Ms. Morrissey. It looked to me like Hancock and Popple kept Morrissey out of the loop on that particular thing, which was a big problem. So, but it was clear in that hearing that 3 of the rounds were visually like the Rust set rounds, which contradicted Ms. Morrissey's statements in her January 8th to undersigned and Ms. Morrissey's in court statements from July 11th that the rounds were not visually similar. Okay, did you investigate that, though? You had the opportunity. See, the thing is that Baldwin said we didn't even know these existed, so we couldn't go and do anything. Bowles, on the other hand, was told that these existed. And the problem for Bowles is that through the application of due diligence, he could have known this. He could have gone and checked them out. So he could have, through the application of due diligence, he could have solved this. That's a bigger problem for Bowles. All right, so what is it? See also Erlinda Johnson interview Supra. I like how he's doing Supra to a citation that isn't actually a citation. Noting that 3 of the Teskey rounds were visually like the Rust set rounds and indicating that this had potential exculpatory value on the theory of sabotage. Further misconduct by the state unearthed in that hearing was that crime scene tech Popple had been directed to place the Teskey rounds in a separate case file with a separate number, not Rust, and create a report that was also filed in that separate case file so that these would not be disclosed to defense. Corporal Hancock testified that Ms. Morrissey was present for that meeting and decision not to place the rounds in a separate case file. However, CST Popple said that Ms. Morrissey wasn't present, and Ms. Morrissey said she wasn't present. I don't know I don't know that I believe Corporal Hancock on this point. In other words, Special Prosecutor Morrissey was in on the decision to hide the rounds and report on them in another file. Moreover, crime scene tech Popple and Morrissey misled this jury in testimony on July 11, 2024, indicating that the Teskey rounds were visually dissimilar to the rust set rounds and therefore immaterial. That was proven false a day later when this court opened the box and inspected the Teskey rounds. Far from distancing from the Teskey rounds, defense counsel recognized their potential exculpatory value had the state tested them, or had defense counsel tested them. Bowles, you could have tested them. You should have tested them. Doing due diligence would have been go test them, right? And this is the problem, is that Morrissey told Bowles they exist and told Bowles that they weren't going to do anything, so he had all sorts of time to take his own steps. So, however, by the time Ms. Morrissey indicated that she did not plan to retrieve them on January 8th, it was too late to utilize these rounds and impossible without the FBI comparison on the powders. Okay. Why was it too late? Couldn't you go and pick them up? Why did you take no steps? Now, I'm just trying to see when I'm trying to see what the trial dates were, and I typoed it, but hopefully they will. When did that trial start? Let's see. Trial begins. When was the trial beginning, or when did it begin? So she was convicted in March, it looks like. Which means that the trial would have been then. You had a couple of months there, dude, didn't you? I'm just trying to remember. When was it? So it sounds to me like you had a couple of months. Why didn't you take that time? And yeah, you could have done your own comparison on the powders. This court had also made clear in one of the motions hearing around that time that there would be no continuance of the February 28th trial date for Ms. Morrissey. Okay. There we go. February 28th trial date. So you got like a month and a bunch. Did you tell the court that you wanted a continuance because there was ammo that needed to be tested? Did you tell the court that? Because if you told the court that and they turned you down, then you have an argument. But if you're just like, oh, the court said that they wouldn't do a continuance, so we didn't bother asking, then that's on you, Bowles. You still have to ask. You still got to ask. So regardless, without the state testing the rounds, counsel for the defense was unable to utilize the powder comparison. You could have done your own powder comparison. Teskey then turned the rounds over to the sheriff's office on March 6, 2024, and the defense hoped that the sheriff's office would finally test and analyze those rounds while Ms. Guitierrez-Reed pursued her appeal. Instead, the state placed them in a separate case file and attempted to hide them. Again, the state is not obligated to do the testing for you. You could ask to do the testing. You could say, hey, I've got an expert. I want to bring a new evidence application. I need to test this. But you can't make them take investigatory steps. And here's the other thing. During the trial, Bowles could have said, isn't there this additional ammunition out there? Yes. And did you ever bother testing that ammunition? No. Bowles didn't explore that at all. So now him saying, I would have used this ammunition, I totally would have done this. You didn't ask any questions about it, sir. I don't know that this part, I think, is just him trying to parachute off of the Baldwin trial. This part I don't think is, I don't think that this part is good enough here. So Erlinda Johnson recognized the import of the rounds, as she stated in her interview, as soon as she saw the 3 silver primer Starline brass on July 12th, when the court took the rounds out of the evidence box, which I think is also when Ms. Morrissey realized the import of them. I think Ms. Morrissey was kind of sandbagged by the investigators. Ms. Johnson indicated that it made the theory of sabotage a possible defense theory, and defense assertions that Ms. Guitierrez Reed was a wonderful armorer. First of all, Bowles, that's not a sentence. And defense assertions that Ms. Guitierrez Reed was a wonderful armorer, what? So maybe have a whole sentence there. Just as a treat, we can eat the entire sentence and not just a portion of the sentence. But also, regardless of what you're saying, she was not a wonderful armorer. Even if you assume that Seth Kenney attempted to sabotage the Rust set, Ms. Guitierrez Reed was, by armorer standards, kind of the equivalent of, like, you go to McDonald's and you're like, I would like a, I forget what sort of cold drinks they have. I'd like a Coke. And you're expecting they're going to serve you a fountain Coke. And instead, they just go and they serve you up a big old drink of toilet water. That's kind of her skill as an armorer. She was god-awful. She was, she was absolutely, miserably dog shit as an armorer. And she should never work again as an armorer. Your whole claim that she was a wonderful armorer? No. God, no. The entire opposite of that, sir. So this goes to the foreseeability element for Ms. Guitierrez Reed as well, and could have been more exculpatory in Ms. Guitierrez Reed's case. The thing is, I think it's still a problem if Seth Kenney intentionally was sabotaging it. The only thing that would happen there is I'd add Seth Kenney to the list of people charged, right? So the import is that Ms. Morrissey and crime scene tech Popple made misrepresentations to the court and jury regarding the Teskey rounds and the circumstances surrounding their late disclosure. I don't understand for the life of me why Bowles is saying Ms. Morrissey is the liar and not saying Corporal Hancock is the liar. I would absolutely be saying that Corporal Hancock was the liar because, A, if she is, that still triggers all of the same disclosure obligations, because as the investigator, she is the representative of the state. And so if she is the liar, it triggers all the same thing, like all of the same issues. But isn't it such a bigger deal if Hancock is the liar? Hancock is the lead investigator in this case. They can eject Morrissey from this trial, but they can't eject Hancock. So, they can run a new trial with Morrissey gone, but Hancock is irreplaceable. If Hancock is the liar, then this case is a lot harder to retry. So, you're kind of going the wrong way here, Bowles, I think. I would absolutely have been setting my sights on Hancock. But these misrepresentations highlight the continued discovery abuses and fraud perpetrated and attempted to be perpetrated on counsel for the defense and this court by the state. Counsel for Ms. Guitierrez Reed knew that Teskey had some rounds from the same batch and is not making that failure of disclosure the sole basis for this motion. Yeah, because I think that actually leads you to fail. So, yeah. I think that would lead that to fail. Lindsay, I saw your comment. I am highlighting your comment. So, except to the extent that they show ongoing misconduct of the state and the failures found by the court, although counsel for Ms. Guitierrez Reed was also never provided with a copy of the police report or lapel video concerning those collected rounds. These additional acts by the special prosecutor should inform, however, the egregious Brady violation regarding the Haag report and the Giglio violation regarding the Seth Kenney interview that was disclosed only after trial. And you know what? I think that those issues are actually the better issues. They are the better issues in this case. And I agree that those issues should get him to a new trial. I don't think that Bowles, and the problem is that when Bowles says in his filing that he was lied to specifically and that he is essentially a witness, when he says he's a witness, he should not be arguing this. And that's a problem. Because if he's a witness, he should be swearing an affidavit to that effect and not arguing this himself. But he's going ahead. All right. So this court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. How can it be any different with Ms. Guitierrez Reed's case with this proven litany of serious discovery abuses? Because you acknowledge you had access to those bullets. Like, you acknowledge that you had that disclosed. So you are differently situated. The intentional withholding of crucial evidence, Brady and Giglio, by the state has compromised the integrity of the entire judicial process. Justice demands that Hannah Guitierrez Reed's conviction be overturned immediately, ensuring that the legal system does not perpetuate this core affront to our system that has been watched all over the world. All right, introduction and factual background. I thought that was the introduction, but I guess we've had introduction, but now we're having second introduction. So was this written by a hobbit? So, yeah. Was this written by a hobbit? I know it's off topic, but could you talk about the filings that Baldwin's attorneys brought up today? I don't know where they brought that up today. So you would have to point that out to me so that I could then look at it. So, yeah. All right. Let us sort of have a look here and see sort of what we're looking at. So, introduction and factual background. At a stunning evidentiary hearing on Friday, July 12th, 2024. Now, I said this in the previous video on this same issue. Normally, I would say stunning is too far. Normally, I don't like the flowery language. I don't like that overall. However, I will agree that stunning, you've earned stunning. You can use stunning. Stunning is okay. Stunning, fair enough. Evidentiary hearing on Friday, July 12th in Mr. Baldwin's trial. This court found that the state had committed an egregious discovery violation by suppressing material Brady evidence regarding the ammunition rounds that Troy Teske turned into the Santa Fe County Sheriff's Office on March 6, 2024. This court entered the extreme remedy of dismissal with prejudice in Mr. Baldwin's case, and it is an extreme remedy, so that is appropriate. Finding, 1, the special prosecutor and sheriff's office suppressed evidence of the rounds that Mr. Teske turned in. 2, the evidence was favorable to Mr. Baldwin as impeachment evidence and potentially exculpatory. 3, the evidence was material in that the late disclosure impacted the fundamental fairness of the proceedings. 4, the state's conduct was highly culpable in failing to provide this discovery and unilaterally withholding a report on the Teske rounds. And 5, the state's willfulness was so close to bad faith as to show signs of scorching. So, 6, this was highly prejudicial to Mr. Baldwin and his preparation for trial. 7, the sanction of dismissal was the only appropriate remedy for the egregious conduct. And 8, despite the state's repeated disclosures to defense and the court that they had complied with all their discovery obligations, they withheld critical evidence. And 9, dismissal with prejudice was necessary to preserve the integrity of the judicial system. The problem, Bowles, is that you actually did get notified that those bullets exist. You had notice. So that's a problem for you. And here's the other problem for Bowles in this, and for Hannah, which is that it's her job to check the ammunition. It's her job to check. Why is it her job to check? Well, because it's possible to get contamination. It's possible that you call up your supplier and you say, I need 500 rounds of dummy ammunition. And somehow they slip a live round in there. That's why you check every single round to make sure no one dies. That's your obligation. And the thing is, it should not have been possible to sabotage by, it shouldn't have been possible to sabotage by putting live rounds on set, because Hannah should have found those. She absolutely should have found them and been like, hey, Hannah had the opportunity to be the hero. To be like, I found the live ammunition. Where did this live ammunition come from? We are going to, we're going to investigate this. But she didn't, because she was sloppy. And Bowles knowing about this ahead of time makes it a big problem. Makes it a big issue, because he could have gone and checked. So that is her. And this is, didn't Carrie say the rounds were not the same as the ones used on set? Did Bowles know that, or did he know that they matched the ones on set? The thing is Bowles didn't actually know, nobody knew that, because they hadn't gone to pick them up. They hadn't actually seen those live rounds until after the trial. Carrie had a picture of some of the live rounds, but nobody had actually gone to pick them up at the time. So that's another big issue there. All right. Now, I just want to note as well, I previously criticized Bowles for his sloppy citation. His sloppy citation gets even sloppier. Even sloppier. See YouTube. Just YouTube. Somewhere on YouTube is a video titled "See Moment Judge Throws Out Case Against Alec Baldwin, July 12, 2024. Did you want to include maybe a URL where we could retrieve that? Which channel was it on? Because I've got questions. Was this on, was this on the Court TV feed? So it's a relatively clear video. Was it on my channel? Was it on Kurt's channel? Was it on the channel of some conspiracy theorist who cuts in the middle of the video to be like, and this is how you know that the reptilians were on it? Whose video are we citing to? It's just somewhere on YouTube there's a video with this title. I should put out a video titled "See Moment Judge Throws Out Case Against Alec Baldwin," and it should just be it should be Alex Jones ranting about the frogs being gay. Sir, you've got to cite. Now you might be wondering, Runkle, why are you pissed off about citations? Why are you pissed off about, because he's a defense lawyer, which means he's got a very serious obligation. Right now, his client is in jail, right? His client's in jail. And he's trying to get his client out of jail. And he is filing things with citations that are below the standard I expect of law students. When I have taught at law school, I taught at law school for 2 semesters. I taught firearms and weapons law twice. I want to teach it more again. It's just finding the time is difficult. So, if a student had submitted a citation like this, I would have put some serious red ink on that page, and I would have been like, you cannot cite this. You cannot do this. There would have been points lost. And I tell my students this. I say, I don't care about citation, really. Citation as a whole is worth 5 marks out of 100. It's 5%. 5% of your entire assignment grade is the citations. And you should get that entire 5%. Every one of you should get that entire 5%. The only way you lose that 5% is if I can't find the thing you're citing to and know it's the thing you're citing to. So I will not fault you for missing a comma. I will not fault you for whatever, but I will absolutely fault you for a citation like this. If this is how you're citing, come on, Bulls. This is BS. I'm not a citation stickler, but this is not appropriate. All right, that's enough of a citations rant. Holy crap. So, yeah, just put the freaking URL in there. It literally would have taken you 0 seconds. Cut, paste, done. So, all right. This is, of course, the same special prosecutor and the same sheriff's office that handled the Guitierrez Reed case. In the same way as in Mr. Baldwin's case, the state represented to counsel and to this court that it had complied with its obligations under the rules. Yet after the trial concluded, the state continued its pattern of discovery misconduct, disclosing a completely new interview of Seth Kenney and a third expert report of the state's expert Lucian Haag. On April 8th, 2024, a full month after Ms. Guitierrez Reed's trial had ended, Ms. Morrissey called counsel for Ms. Guitierrez Reed and disclosed an entirely new Seth Kenney interview and statement that contained numerous points that could have been used in Seth Kenney's cross-examination. Also, the state withheld bombshell exculpatory evidence that it had a constitutional obligation to disclose and that would have resulted in a fundamentally different trial and likely a different outcome. I don't know about different outcome, but okay, I do think he should have gotten it. I don't know that it would have changed anything, but I do think he should have gotten it. Now, I just want to note here, he says that he got that call on April 8th, 2024. You know what hadn't happened yet at the time of April 8th, 2024? You know what hadn't happened yet? The sentencing. The sentencing hadn't happened yet. You don't think you bring an application for an emergency retrial when the sentencing hadn't happened? And you know what they do instead? They file on April 10th. They file their sentencing memorandum. April 12th, the state files their response. April 14th, they file their state's response to, or the defendant's reply to the state's response. April 18th, they get judgment and sentence. May 7th, they make a motion for release pending appeal. And what that motion for release pending appeal says is nothing about this new, this new disclosure. Why aren't you mentioning it on May 7th? Okay. May 13th, he files a notice of appeal. What happens in the notice of appeal? Well, he doesn't actually mention this issue. He instead goes on a jury instruction interview, and that's his big issue. His jury instruction issue, by the way, is garbage. It is not good. So that's his notice of appeal on the 13th. He does nothing on this for months and months and months and months and months and months and months. And here's the problem he's got, which is that if he wants to argue this as this should get me a new trial, he should really have acted as if this was a big issue at the time. He really should have said, hey, this is a big issue at the time, because him not doing it then kind of suggests that he didn't think it was an issue at the time. And here's the other thing. If he is now saying that this is a big issue, that failure to disclose that Seth Kenney interview, then by implication, what he's telling the world is that he is actually a garbage lawyer. And what I mean by that is he's saying, I got this super important information on April 8th, and I let my client go to jail over it without raising a simple, without raising a fuss, without saying boo about it. I let my client go to jail. I let her sit there from April to May, May to June, June to July. Why? Because I guess fuck her, I guess. Did you not realize this was important, sir? Did you not think maybe I should try to get my client out? Because yeah, you totally should. You totally should. By the way, I found something I thought I'd lost, and I just kind of want to share it with you guys. I got this at SHOT Show. I need to get a display for these, by the way. But I got a challenge coin. I'm just going to show you guys because I found this earlier when I was cleaning up my car. It had fallen through into the seat. I got a challenge coin from the Office for Bombing Protection, which is really cool. I'm going to start collecting and properly displaying all of my challenge coins. So I got to get a display for that. So yeah. All right, back to what we're doing here. So also, the state withheld bombshell exculpatory evidence that it had a constitutional obligation to disclose, and that would have resulted in a fundamentally different trial and likely a different outcome. I don't know about the different outcome. As the court is aware from ongoing proceedings in Ms. Guitierrez Reed's and Mr. Baldwin's case, despite having in its possession a report from its own experts stating that the firearm used on the set of the Rust film contained unexplained tool marks on critical surfaces of the trigger and sear, which one, likely were not the result of damage incurred during the FBI's impact testing, and two, do not appear to be original manufacturing marks or use and abuse marks based on their irregular orientation, the state buried this information and never disclosed it to Ms. Guitierrez Reed. Somebody's asking, what is a challenge coin? We'll come back to that later. But not only that, the state called the expert at trial and sat idly by as he perjured himself during cross-examination. I actually think that this is total bullshit. Total bullshit, and I'm going to explain why. He's saying that the state sat there as he perjured himself during cross-examination. It's actually the case that Mr. Haag initially said, I thought that these were some weird tool marks. And then after he did some further consideration, he's like, oh, no, they're not weird after all. I thought they were weird, but they are not. So he says, yeah, they're not actually weird. So at the time he testified, he was like, yeah, no, those are explained tool marks. They are perfectly understandable. And so he wasn't perjuring himself. He just had changed his mind. But the defense was entitled to put to him, didn't you think this other thing initially? They should absolutely have been able to put that to him. I agree 100% on that. So in doing so, the state, 1, suppressed exculpatory material in violation of the U.S. and New Mexico constitutions, 2, suppressed a testifying witness's written statements in violation of the rules of court, and 3, committed additional violations of the U.S. and New Mexico constitutions during trial. This conduct is beneath what the court should expect from a duly appointed officer of the state tasked with doing justice. These late disclosures occurring after trial had concluded violate Rule 5.501H, and there's a reasonable probability that the outcome of the trial may have been different had the state complied with its obligations. All right, so there we are. I agree that this is a big deal that they didn't get it, but yeah. So people are asking, what are challenge coins? So challenge coins were initially a military thing. They're still a military thing. The challenge aspect of them is basically that people would basically pull out challenge coins and sort of try to one-up each other. And you would end up buying drinks if one of two things. If A, you didn't have a challenge coin, you end up buying drinks when everyone else is slamming one on the table. So if you forgot to bring it, you're in trouble. But B, if you had the least cool challenge coin. So you'd get people who would basically just, you plunk it down. And I heard a funny story about one who had a challenge coin from, like, at the time, I'm trying to remember his name. Legendary U.S. general or legendary U.S. I'm trying to remember the name of the guy. I'm just doing a search for the 5 greatest generals because it's going to come up. Not George Washington, not Winfield Scott, not Ulysses Grant. Okay, none of those people. They're all too historical. What is the greatest recent general? What was his name? Somebody in the chat, tell me, somebody in the chat knows who I'm thinking. Was it Mattis? Yes. Mattis. They had a challenge coin from Mattis. Mattis is a bit of a legendary figure. And so he basically said that a lot of the time he would go out there and he would end up doing, great things or he would win those challenge coin off. So, yeah. Now his story about how he got it is, it's sort of a long thing to say, but yeah, he got a challenge coin from Mattis and it was just like plunk. Somebody says, actually, you pull it out, tap it on the bar, then everyone else has to tap. Coin rank only comes up in certain situations. Normally, the rank doesn't matter. Source, I'm former Air Force. Okay. Might also be different traditions because I am Canadian, so I talk to Canadian people. So that said, the guy with the Mattis coin was American for fairly obvious reasons. But yeah, he said that always served him well when he was able to pull that out. So, yeah. All right. So, yeah, they are a bit of a tradition. They have bled into the civilian realm. And so I am planning to... some people have asked me if I will sell challenge coins, and so I'm planning to sell some. That said, I'm in the process of having challenge coins made. And the challenge coins will have 2 levels to them. If I get the challenge coins made, there's going to be the default challenge coin is going to have no color to it. None of this like blue or red or anything like that. It's just going to be a metal challenge coin, pure metal. There's also going to be another level, which will be the colored challenge coins, and those will be earned only. Those will be only given out at my discretion for situations that I think are awesome. So that's the plan. All right. Challenge coins have been explained. We're going to move on. The suppressed Seth Kenney interview. In the Seth Kenney recorded interview conducted well prior to trial of Guitierrez Reed, there's no date contained in the interview, but it occurred well before trial. Mr. Kenney makes the following material statements that counsel for Ms. Guitierrez Reed would have used in cross-examination. Now, I'm just going to note, that I don't think that any of these statements are super huge. That said, I actually think that the issue that there's a statement entirely is a big deal. The issue that there's a statement entirely is a big consideration because anytime a witness gives a statement and you're going to cross-examine that witness, you want more statements, right? You want more, like if you're the other side, you want more statements because there's going to be contradictions. Having a statement like this for cross-examination is fantastic. So, yeah. So 1, there's a standard that the prop master, Sarah Zachary, is the boss, and if something goes missing or stolen, she must report it. She is managing things which allows the armor to focus on guns, and Sarah is everything else. So 2, Hannah grew up on the set of movies and has a lot of immersion in set history. She has more experience with Westerns than Seth did up until 1883. 3 says prop masters who can't who handle guns won't call out the armorer to test bullets. Okay. 4 mentions that the sheriffs confuse the replica gun with the real gun. Yeah, that's why it's a replica. No kidding, this sheriff would do that. So Sarah told him Hannah was doing great with the guns and the director was happy. Yes, I'm sure that is true, that people said that Hannah was doing great. The thing is people tend to think the safety person is doing great if they're not slowing up production right up until someone dies. You reassess somebody's performance if somebody dies, right? Like, let's say I hire somebody to clean up the dog poop in my backyard, which I do occasionally. Let's say I do that. Well, and I've done that in the past. I would think they're doing a great job, but my impression of how great of a job they're doing would be greatly diminished if there was a dead body in my backyard when they were done, right? That would be a thing, right? Similarly, like if you go to your favorite restaurant and everything is doing great and you'd be like, hey, this is a great restaurant, but your impression of the restaurant will change dramatically the day you find a human tooth in your soup, right? Or even just a Band-Aid. So, yeah. So next, Seth heard nothing but good things about Hannah's skills. All the stuff that came out after her about safety, he hadn't heard. He wasn't on set. Nobody was telling him the bad stuff. He felt like people were piling on after the fact. He mentions the anonymous hotline and that if there was something going on, why did nobody call the hotline? And Alex Hancock has been cool, but I busted her chops on the search warrant. He says he got 325 rounds from Thel Reed. He says sabotage could be anyone on the set. Okay. He says it's a boys' club. Alec trusts the AD because he's a man. If she said she got pushed around, no one would disagree. She's got the experience. If she ever came up with that kind of defense, then I'd think finally, you're going to be real about this thing. If the camera crew didn't feel safe, well, then call the hotline. It's kind of suspicious to me. If they got their hotels, would they have said that they didn't feel safe? Maybe. He talks about Sarah's accidental discharge. Sarah was super responsible and apologized to everyone. Hannah was trying to punch down on Sarah for accidental discharge. Accidental discharges happen. He mentions Tim McGraw, Daniel Craig, and Denzel, I assume Denzel Washington, having them. He told Hannah to let it go about Sarah's accidental discharge. As to Hannah, he says that the AD and Baldwin, how are you not making sure a 24-year-old armorer has every ounce of support? She's got the experience and history. She's had more set time on Westerns than I did before 1883. All right. Sarah was collateral damage. He told her he would find an adult armorer. And then Hannah came out strong. She was pushed around by Baldwin and the AD. Props department needs every ounce of support. And he says sabotage is bullshit. I agree with that. I agree with that entirely. So, several of these statements are new and different and would have been critical to cross-examination of Mr. Kenney. Fair, absolutely. Including to show Ms. Guitierrez Reed's experience, that allegations of her being unsafe were not something Mr. Kenney had ever heard, that props and armor needed more support, that if the camera crew or others did not feel safe, they should call the hotline. Most critically, he said he received 325 rounds from Thel Reed, which is important because the ammo can found at his shop, PDQ, was found empty during the search warrant. Okay, good, cool. Mr. Kenney also represented in the Friday, July 12, 2024 hearing that he brought back 50 to 100 rounds with him to New Mexico and no explanation as to where they went. The state also made repeated points at trial about guns being left unattended. Yet in his previously undisclosed interview, Kenney said that the sheriff confused real and prop guns. Yes, but they acknowledged that real guns were left unattended. Okay. Kenney also made conflicting statements on sabotage. This was favorable Giglio information that the state suppressed and that was material. Failure to produce is a violation of the law, so we think that's an issue. All right. Suppression of the Haag report. The accident involving the firearm that led to the indictment. So here's the thing. I don't think any of those statements would have changed my mind about Hannah Gutierrez Reed. I don't think any of those would have changed my mind on this. But I agree that they should have had them and that they should have been able to make those arguments. So fair. Fair. Suppression of the Haag report. The accident involving the firearm that led to the indictment of Ms. Guitierrez Reed occurred on October 21st, 2021. The state first charged Ms. Guitierrez Reed with involuntary manslaughter on January 31st, and trial commenced February 28th, 2024. Ms. Guitierrez Reed's principal defense theory was that no one had committed a crime and that this was a tragic accident, and that if there was any negligence, it was on the part of the producers, as found by OSHA. This defense would have been imminently bolstered by a legally unforeseeable intervening cause, such as a firearm malfunction, that caused Ms. Hutchins' death. This is perhaps the most important evidence in the case of an unforeseeable intervening cause. Indeed, post-trial, one of the jurors called undersigned counsel and said the jury was split and that they ultimately thought the tragedy was foreseeable and there was no intervening cause that broke the chain of causation. In short, the Haag report is critical new evidence. Here's the problem. Here's the issue. Whose job was it to make sure that the ammo or that the guns on the set of Rust were functioning properly? Whose job was that? Would it be like those are armaments? So might it be the job of the armorer? Who was that armor? Oh shit, that was Hannah. That was Hannah's job. And the other problem is that the other issue is even if the gun was crap and went off without anyone pulling the trigger, like even if this gun was literally possessed by Satan, it was something out of a like Stephen King novel that this gun just goes off randomly in order to cause cause accidents. The whole live round thing in it is a big deal, right? The whole live round thing is absolutely the problem. So yeah. Ducati girl, could someone clarify, please? Picks sent to carry of retained rounds were different from those presented to the court in the bag. Yes. They got a picture from Teskey of the rounds, which showed bronze primers, but they didn't actually go and check it. Why does everyone blame Satan? Because I'm Canadian. I can't blame Canada. And nobody's ever heard of a gun being possessed by Canada. Like that just makes no sense. All right. On March 6, 2024, the jury returned a verdict finding Ms. Guitierrez Reed guilty of involuntary manslaughter. The district court entered judgment on April 18, 2024, when it sentenced Ms. Guitierrez Reed to the maximum statutory penalty of 18 months imprisonment. So, yeah. But what neither the court nor the jury nor Ms. Guitierrez Reed knew was that months before Ms. Guitierrez Reed's trial, the state's two firearms experts, Lucian Haag and Michael G. Haag, issued not just the one report that the state disclosed, but two subsequent reports. The prosecutor said that she thought those had been disclosed and that then she checked the disclosure thing and was like, whoops, I didn't disclose them. My bad. Oh, Shells Wheelie. Guys, I'm so stupid. I helped talk the guy I like into a relationship with someone else. When he asked me for advice, I helped him with it. Now I'm sad about it, but I also want him happy. Shells Wheelie, you did the right thing, giving good advice. I know it's going to suck, and I am going to open a drink for that. That calls for something. So breaking out a thing, because yeah. Cheers. All right. So the result of the Haag's second examination, performed on April 24th, 2023, were published in two separate reports. The third Haag report found that the firearm contained unexplained tool marks on the working surface and the sides of the evidence trigger and sear, and that it was unlikely that these tool marks are the result of the damage incurred during the FBI's impact testing, and that the tool marks do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. So here's the thing. Haag ultimately determined that he was wrong about that they weren't signs of a modification. That's what Haag ultimately determined. But the defense should have been afforded the opportunity to challenge Haag on the fact that he came to a different conclusion midway along the line. They should have been offered that opportunity. And so I agree that this is an issue, that this is a real issue here. All right. So, put another way, the state's experts concluded that there were unexplained alterations to the firearm's trigger/seal. It's the sear, S-E-A-R, sear, not seal. But he's going to say seal a lot in this because he did not proofread that. A critical conclusion, given that Ms. Guitierrez Reed's co-defendant, Alexander Baldwin, has claimed that he never pulled the trigger of the gun prior to its firing the bullet that killed Helena Hutchins. Here's the thing. I think that is critical for Baldwin. That's essential for Baldwin. It's not essential for Hannah. Hannah's theory, like the theory that of liability for Hannah, is way worse. Here's the other problem, is that this report was mentioned in the Baldwin proceedings a while ago. So why didn't you bring this application when that came out? The other problem I have with all of the ammo stuff, I mean, I don't think that this would have changed my verdict in the slightest, but I do think that the defense should have been able to have this. The state, however, did not produce the third Haag report prior to the commencement of Ms. Guitierrez Reed's trial. Instead, the state produced them only to Mr. Baldwin, and only weeks after a jury had convicted and the court had sentenced Ms. Guitierrez Reed. It was only on May 31st, 2024, by which time Ms. Guitierrez was already at the Western New Mexico Women's Prison in Grants for intake and classification, that Special Prosecutor Morrissey admitted to Mr. Baldwin's counsel that the state failed to disclose the supplemental report for almost 9 months, and that such failure was mine. Now, when did you find out about this? Ashley, I did do this earlier today. We're doing it again for the people who were at work or asleep or whatever else. It's an experiment. It's an experiment here. So, we're just seeing how this goes. So the timeline of the state's discovery disclosures in Mr. Baldwin's case is important to understand for the purposes of this motion. On January 24th, 2024, Mr. Baldwin made his initial discovery demand. Between April 22nd and April 29th, 2024, Mr. Baldwin repeatedly raised concerns to the prosecution about missing expert materials and other missing discovery. Then, on April 29th, 2024, Mr. Baldwin apparently learned of the second Haag report when Lucian Haag referred to it during his pretrial interview. When did you learn about it? This is critical to you, right? When did you learn about it? Like, Bowles, when did you know about it? And then it was more than a month later, on May 21st, that Mr. Baldwin's defense learned of the existence of the third Haag report during the pretrial interview of Michael Haag. When did you learn about it, Bowles? That's relevant, because if you knew about it and you sat on this for a time, that's going to be considered as well, right? So when did you know? Meanwhile, the state was actively prosecuting Ms. Guitierrez Reed. Her trial began on February 28th, and they delivered a verdict on March 6th, and the court imposed sentence on April 18th. and during Ms. Guitierrez-Reed's trial, her attorney examined Lucian Haag about the precise exculpatory issues raised in the third Haag report. All right. Mr. Bowles says, okay, sir, and in your inspection of that weapon, that Baldwin revolver, did you see any modification that would have changed the firing characteristics of that weapon? And he says, no, not at all. Now, this is, he actually doesn't think that those would have changed the modification or changed the firing characteristics. And then Mr. Bowles says, okay, sir, so other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage. And he says, I did not. Now, Bowles is saying that this is perjury. Bowles is saying that this is perjury because he'd made a report that earlier concluded that there was weird marks. The problem is that in between that third report and the trial, he concluded that those weren't evidence of modification. He concluded that that was normal. And so because of that, it's not perjury. It's just like his own issue, so, but he should have been able to put that to the witness. That's the thing. It's not perjury, but it absolutely should have been something that he should have been able to cross this witness on. So at the same time that Lucian Haag gave this sworn testimony, the state possessed a report stating the exact opposite, specifically that the firearm contained unexplained tool marks on the working surface and sides of the evidence trigger sear that unlikely are the result of damage incurred during the FBI's impact testing and do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Although Lucian Haag's trial testimony directly contradicted his conclusions in the third Haag report, the state continued to withhold the third Haag report and its contents. I agree that they should have had it, right? And yeah, this is a problem. If he admits when he learned about it, it'll be harder to piggyback off Baldwin's acquittal. Also, he'd have to explain why he sat on it for so long. Yep. With the third Haag report, Ms. Guitierrez-Reed would have a sufficient evidentiary basis from which to argue that unexplained alterations to the firearm caused it to fire without anyone pulling the trigger. That would be a terrible thing to put a live round into, right? Good thing no one put a live round into that one. An unforeseeable intervening cause that rendered her conduct not legally responsible for Ms. Hutchins' tragic death. Yeah, I don't know that it is, but okay. I don't know that it is, but it is a question for the jury to answer. Not me, not Morrissey, not even Bowles. It's a question for the jury to answer. This was the critical factor in the jury's decision under the instructions as given. Nor was she able to impeach Mr. Haag's testimony with his prior inconsistent statements. And a few weeks after that testimony, the jury convicted Ms. Guitierrez-Reed of involuntary manslaughter. So, suppression of additional material. This week, the Guitierrez-Reed defense has also become aware of another possible 900 or so pages of material related to state witnesses Brian Carpenter and Haag that was not disclosed to undersigned counsel. That's a lot of pages, right? This material was disclosed to counsel for Mr. Baldwin shortly before his trial. It appears that this material consisted of email communications between the state and those witnesses that were not disclosed by Ms. Morrissey. Counsel are still reviewing these at the time of filing this motion and may supplement with exhibits in a reply. Fair enough, right? They got 900 pages. It's going to take them some time to read those 900 pages. Fair enough. I'm not going to fault him on that. It is too important for Ms. Guitierrez-Reed to have her motion filed immediately, given the July 12th hearing and findings. Yeah, she's in jail. And you've already admitted by your own implication that you sat on things for months from when you got them to when you acted on them. But I mean, now you're going to act fast. That is the right call to act fast now, but maybe you should have acted faster before. I needed some caffeine, and I needed the temperature in here is something else. My AC is working as hard as it can, and it cannot compete. So, as just one example, attached as Exhibit E are numerous emails approximately 36 pages. It's not actually 36 pages. And you know how it's not 36 pages? Because at the bottom here, this whole filing is 35 pages. So how can the emails be 36 pages if the whole filing is 35 pages? I'm just a lawyer. I'm not a math wizard, but I have a feeling that 35 pages is less than 36 pages. That's just, lawyer math. We're just lawyer mathing it here. Okay. Okay. So, yeah. Now, he does identify some things that I think are extremely, extremely concerning. And I agree with him that these are concerning things. So, what does he identify here? What does he identify? Well, he says, team, first off, excellent job, Robert. Very compelling document and well written. I have redlined anything I found notable. Here's the problem. Carpenter should not be part of the team. Carpenter should not be on the team. Carpenter is supposed to be an expert, which means he's supposed to be unbiased. He's supposed to be a neutral party, not part of the team. And so if Carpenter finds himself to be part of the team, then that suggests that he's got some bias maybe, and he should have been able to be cross-examined on these points. So, in another, towards the end, he appears to email additional thoughts regarding Mrs. Gutierrez-Reed's probable cause statement. As this court may recall, Brian Carpenter was the state's expert witness in the Gutierrez-Reed trial as well. This email is one the counsel has located in cursory search, demonstrating the expert's bias towards the prosecution and the fact that he's involved in helping draft a probable cause statement supporting charges. I agree, that's inappropriate. I actually think that Carpenter stepped over the line here. And if Carpenter becomes a participant, if he becomes like an agent in this, then the court should reject his evidence. And the jury would consider that as well, right? So, yeah, that's a problem. In yet another, he states that Sarah Zachary knew nothing or next to nothing about firearms. He goes on to state that her hiring was for low-budget reasons, and the only thing to mitigate that was to hire an experienced armorer, but that didn't happen again for more than likely for low-budget reasons. Again, blaming production. You know who shouldn't have taken the job if she's... Like, here's the thing. Let's say somebody comes to me tomorrow and they say, we want you to be the safety guy, the safety engineer for NASCAR. All of NASCAR, you're going to be the safety guy. And it's going to pay $750,000 a year, which is more money than I've ever even thought about making in a year in my life, right? $750,000 in a year is a lot of money. Let's say they come to me and they say, Runkle, this is the offer. We want you. We've watched your YouTube videos and we think you are the guy to be the safety person, like deciding track design and, which fire crews should be working, which rescue crews, and we're going to pay you a whole ton of money. I would have to say no, because how the hell do I take a job where people's lives are on the line, which I know nothing about? I haven't even watched an entire NASCAR race. Like, not once. I did watch the Gran Turismo movie. That's as close as I come to having any knowledge of car racing, as I watched the Gran Turismo movie. It was actually surprisingly entertaining. So if you can't do the job, don't take the job, right? That is the critical thing. So, yeah. In another email dated November 17th, 2022, Carpenter writes to prosecutors that he's talked to one of the top 3 prop house owners in the U.S. and a very well-known prop master, and both of them, without hesitation, felt a major amount of responsibility fell on the prop master. He goes on to believe Hannah is very accurate in saying her statement that they, production, were jumping her ass for not working hard on props and that they wanted more done in the props area to save money. Your job is to walk. If you can't do the job because you're not given enough time, you walk and the guns walk with you. That's the job. That's the job. That's the job. So he states that Gabriel Pickle was the one from production who stonewalled all the training and armor day requests. He references people believing Gabriel Pickle and members of production being responsible. He notes further blame on production in bringing the props master and armor in late, not giving them a props truck, and having locations working out of the same truck as being completely wrong and the fault of production. These were all themes that Ms. Guitierrez-Reed espoused at trial, and she never had access to these statements to cross the government's expert, Carpenter. I don't think any of this matters, except that they should have been able to cross-examine that, right? And yeah, fun fact, armor and lawyer have that in common. If you can't do the job, it's your job to turn it down. This came up with the lawyer handling my boyfriend's dad's estate. If I, as a lawyer, I have never run like a complex oil and gas litigation. I've never done that. It's civil litigation. It's complicated. I just don't know what I'd be doing in it. I would need some serious learning to venture into that. But if I do venture in to taking on that kind of case, then I'm responsible for doing a good job. And if I do a shitty job at it, then I can be sued for it, right? I can be sued for my mistakes. I am on the hook for it. So, yep. In another email of February 6, 2023, Carpenter states that he's reviewing something that appears to reflect a total of 86 live rounds, which is a big thing as they were scattered throughout and found at PDQ. This is Seth Kenney's business, and the number of live rounds found at his business was a source of major contention at trial. Again, something they should have been able to cross him on. Again, these are all statements required to be disclosed under the law. The repeated discovery failures are certainly beneath what Ms. Guitierrez-Reed deserved, and for her, the impact has been devastating. She now sits in state prison serving an 18-month sentence based on what we now know was a proceeding that was rendered unfair and unconstitutional by the state's conduct. This court should not countenance the state's deplorable behavior. So now we get to law and argument. Okay, so now we're going to get to the law, the meat of things. The state violates the defendant's due process rights when it suppresses evidence favorable to an accused upon request, where the evidence is material to either guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. This is important. It doesn't matter if the prosecution was behaving, was acting in good faith. It's just, did the evidence get there or not? So, evidence qualifies as material when there is any reasonable likelihood that it could have affected the judgment of the jury. To prevail on her Brady claim, the defendant need not show that she more likely than not would have been acquitted had the new evidence been admitted. She must only show that the new evidence is sufficient to undermine confidence in the verdict. That's important because you don't have to show that you would have won. Is my hair shorter? No, it is not. To the great annoyance of my wife, who does want me to get it cut. I will probably do that soon. I need to go get a haircut. I am behind on that. So, but right now it is not shorter. So the state of New Mexico imposes a heightened obligation, and in particular, they have to disclose any statement made by any witness whom the prosecutor intends to call at the trial that is within the knowledge of the prosecutor, whether or not it's relevant. Okay. When a defendant has been found guilty, the court on motion of the defendant or on its own motion may grant a new trial if required in the interests of justice. A motion for a new trial based on newly discovered evidence is appropriate where that evidence will probably change the result if a new trial is granted and was discovered after the trial. Note, he's got a bit of a problem here because he very much doesn't say when he knew things, right? He doesn't say that he doesn't say what he knew things. What will I do with my hair? I'm going to leave it on the floor of the hair cutting place. That's what I'm going to do with it. Do we get to ask who cuts your hair? It's either super cuts or ultra cuts or somebody. Don't be creepy about it. I'm not going to cut it short. I'm just going to cut it like an inch off just to tidy it up at the bottom. We're not going down to short hair. We're not doing that. So, all right. The court should order, or 3, could not have been discovered before the trial by the exercise of due diligence. G, you could have discovered due diligence. Due diligence like going to get and test those rounds. 4 is material. 5 is not merely cumulative. And 6 is not merely impeaching or contradictory. Okay. So the court should order Ms. Guitierrez-Reed to have a new trial or for dismissal. So you know how they keep going with new trial or dismissal, but they keep arguing for new trial? That's what they're looking for, right? So Ms. Guitierrez-Reed is entitled to a new trial or dismissal. Prosecutors bear significant responsibility in the administration of the law, and it is as much their duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. And then they're going to quote the thing that they always quote, the thing that they always quote, which is Berger. A prosecutor may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. This is one of those quotes that everybody likes to quote. So yeah. Don't go to Crooks; he'll nick your ear. Jesus. I was just like, what is that? Oh God. So the conduct of the state in this case is exactly the evil the court had in mind in Berger, and again in Brady and Giglio. Under Brady, the state is required to disclose favorable evidence to the defense upon request. Critically, the U.S. Supreme Court has held that the state violates the defendant's due process rights when it suppresses evidence favorable to an accused upon request, where the evidence is material to either guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. You already said that, sir, just a moment ago. Moreover, the prosecution for Brady purposes encompasses not only the individual prosecutor handling the case, but extends to the prosecutor's entire office, as well as law enforcement personnel and other arms of the state involved in investigative aspects of the case, i.e., crime scene technician Popple or, Hancock. If they're at fault, then the state is at fault. So, yeah. There can be no legitimate dispute that the state violated Ms. Guitierrez-Reed's due process rights under Brady, given that it has now stipulated that it failed to disclose evidence that is both favorable to Ms. Guitierrez-Reed and material to her guilt. As to the first factor, the third Haag report is favorable to Ms. Guitierrez-Reed. I agree with that. It is. 100% it is. It corroborates the defense theory that exculpates Ms. Guitierrez-Reed. I disagree that it exculpates her completely, but that's a question for the jury, right? That's for the jury to decide. And would have changed jurors' weighting of the evidence in essential ways. Whatever conduct the state alleged against Ms. Guitierrez-Reed, that conduct was not legally responsible for Ms. Hutchins' tragic death, because no one could have foreseen that unexplained alterations to the trigger/seal, which should be sear, would lead to a freak malfunction causing the gun to fire. Whose gun was it? Who was the armorer? Who was responsible for the gun to to be functional? And also, how could it possibly have gone off if there was not a live round in it? Who put the live round in it? So, yeah. If the jury had credited this theory, which the state's own expert reports would have corroborated, the jury necessarily would have acquitted Ms. Guitierrez-Reed. I don't think so, but okay. So the defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death and without which the death would not have occurred. So they're saying it breaks the chain of causation. I don't know that it necessarily does, but okay. But Ms. Guitierrez Reed was not able to pursue that theory because the state buried evidence in its possession that was necessary for her to make that case to the jury. Nor did Ms. Guitierrez Reed fail to ask the right question. She asked specifically and repeatedly that the state produce all evidence subject to Brady and Giglio, and then at trial, even without knowing that Lucian Haag had opined in writing in the third Haag report that there were modifications or damage to the firearm other than what resulted from the FBI testing, Ms. Guitierrez Reed asked that specific question, which they quote this same thing again. You already quoted it, sir. We don't need it again. Okay. The fact that Ms. Guitierrez Reed asked the question and Lucian Haag perjured himself in response should dispel any suggestion that the truth, memorialized in the third Haag report, would have been exculpatory as to Ms. Guitierrez Reed. Lucian Haag's perjury likewise supports the second factor, that the third Haag report was material to Ms. Guitierrez Reed's case. Evidence qualifies as material when there's any reasonable likelihood that it could have affected the judgment of the jury. And here's the thing. I think it could have affected the judgment of the jury because the jury could have said, listen, we don't think Haag knows what he's talking about. We don't think he knows what's going on. To prevail on her Brady claim, Ms. Guitierrez Reed need not show that she more likely than not would have been acquitted had the new evidence been admitted. She must show only that the new evidence is sufficient to undermine confidence in the verdict. So, showing that the defendant can prevail even if the undisclosed information may not have affected the jury's verdict. The facts of this case far surpass that low threshold. The state's entire theory of guilt was that Ms. Guitierrez Reed's criminal negligence in mishandling the gun caused the death of Helena Hutchins, and that her death was a foreseeable consequence of Ms. Guitierrez Reed's negligence. Ms. Guitierrez Reed's trial strategy was built on the assumption that there was no evidence suggesting the gun may have been modified or damaged at the time the incident occurred. Had the state disclosed the third Haag report, Ms. Guitierrez Reed could have used its content to sow reasonable doubt as to causation generally and foreseeability. Ms. Guitierrez Reed never got the opportunity. I agree that they should have had the chance, and that is, I think that is fair, right? Yeah. So, all right. So, let's see. What is it? The fact that Lucian Haag perjured himself about this very subject, I don't think it was perjury. Again, I think he goes too far there. When he testified at Mrs. Guitierrez Reed's trial, and that the state continued to dissemble about the third Haag report for months when Mr. Baldwin continued to press, only underscores how important the state views this evidence. Mr. Haag was cross-examined on this point, and I don't think he perjured himself. Like, he explained very clearly what happened. There's no conceivable reason to lie and deceive about something that doesn't matter. Again, I think they're overselling the point at this point. Whatever the state's intentions, there is no dispute that it failed to disclose the third Haag report until after Ms. Guitierrez Reed's conviction and sentencing. And that is all that matters. And if that's all that matters, you don't need to bullshit up about those things, right? We don't need to. We don't need that. So yeah. All right. So why go further? Why do you don't venture into hyperbole when you don't need to? When you don't need to. So whether this suppression was inadvertent or intentional does not affect the Brady analysis. So violation occurs when the suppressed evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. The state's failure to disclose the third Haag report to Ms. Guitierrez Reed until months after her trial constitutes a violation of her due process rights under Brady that warrants a new trial. While the violation of Ms. Guitierrez-Reed's rights under the Constitution is sufficient to vacate her conviction and order a new trial, her rights under the New Mexico Constitution are even more expansive. Under New Mexico law, Ms. Guitierrez-Reed is entitled to a new trial because the state violated its duty to disclose evidence that was material and thereby prejudiced Ms. Guitierrez-Reed. So first, the state had a duty to disclose the third Haag report under New Mexico law. So they say it requires disclosure of any documents which were within the possession of the possession, custody, or control of the state, and which are material to the preparation of the defense, and any statement made by a witness that is within the knowledge of the prosecutor, and any material evidence favorable to the defendant. If you're starting to feel like this is a little bit repetitive, it is. A whole bunch of this should have been cut on edits. And yeah, is this the judge's ruling? No, this is Bowles' filing. This is Bowles' movement. Hello, Court TV. How are you doing? How are you doing? So yeah. Second, the improperly withheld Haag report was material. You've argued this like 4 times now, Bowles. Like, you keep looping this, and the fact you're repeating yourself is a problem. Court TV says, just saying hi. Hi, Court TV. Good to see you. Good to see you. So whether evidence is material depends on if there's a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. So applying the standard in the failure to disclose context, New Mexico courts, including the Supreme Court, repeatedly have held that information that would certainly impact a defense counsel's tactical trial decisions is material to the defense. So, yeah. For the reasons above, the state's failure to disclose the third Haag report undoubtedly affected Ms. Guitierrez-Reed's trial strategy and was therefore material. Runkle, wouldn't what he's saying actually change the verdict? It doesn't look like it to me. The thing is that it might. It might. The jury, you don't know what a jury's going to do. I think that there is enough there that I would be inclined to grant a new trial, even though I think it's partially BS, right? So, third, the state's failure to disclose the third Haag report to Ms. Guitierrez-Reed until months after the conclusion of her trial was prejudicial. So, in State versus Allison, on the way to finding the prosecutor's failure to disclose evidence prejudiced the defendant, the New Mexico Supreme Court stated that had counsel been aware of the undisclosed evidence, he may have altered his strategy. So too here. Had Ms. Guitierrez-Reed's counsel been aware of the third Haag report, he undoubtedly would have modified his trial strategy to attempt to introduce a reasonable doubt. I hate the introduce a reasonable doubt. You don't introduce a reasonable doubt. Reasonable doubt exists before you get there. He would have attempted to argue, that about the gun's functionality at the time of the incident, and it would have been impossible for the prosecution to disprove this beyond a reasonable doubt. That's the argument. I hate the introduce a reasonable doubt. At a minimum, Ms. Guitierrez-Reed would have been able to use the contents of the report to impeach Mr. Haag's contradictory testimony. Now, here's the problem, is that the case law says it can't be merely impeachment. So that's a problem. The state deprived Ms. Guitierrez-Reed of the opportunity to do so and severely prejudiced her in the process. So they say, entitled to a new trial. Now, here's the fun thing. They go, in the alternative, the court should grant Ms. Guitierrez-Reed release pending appeal. And this one's going to have some interesting problems, interesting issues. So we're going to stop for a second, though, because we are behind on some super chats, and I'm going to cover those before we move on to the release pending appeal. Marty Herford, thank you for the gifted membership. Much appreciated. Vomit Fountain. That is a username. Really appreciate the second stream. I know it's extra work for you and the mods. I appreciate it. It is, my voice is getting pretty scratchy, I will say. Kate, maybe if she does get a new trial, can Morrissey prosecute, or is she now a witness? How's that work? I think she could theoretically prosecute, but if I was her, I would get the heck off this. Also loving the double Runkle Day. My vote is yes. Thank you so much. Claude Simeon, isn't testing expensive? How much could Hannah Guitierrez-Reed spend? That ultimately is on her. If she couldn't afford it, she should have made a court application for something along those lines. Carson Pratt just realized visually similar rounds only showed up after the rounds and powder were shown in the trial. An experienced loader could have made matching rounds. Absolutely. In fact, these things we only see the nickel primer ones after this information came out in the Hannah Guitierrez Reed trial. And they talked about which powder it was, the Trail Boss powder. So, I will say, I could have made fakes. I mean, I didn't. But I suspect the prosecution thought that there was a very real possibility that this was evidence tampering. I bet that's what Morrissey was thinking, that this was interfering with an investigation. Cindy T, thank you for the 5 gifted memberships. Much appreciated. Lindsay, fun unrelated news. According to EDB, paper airplanes are the bad bitches Aperol Spritz. So Ian is now officially a bad bitch. I love a paper plane. It is a great cocktail. It is lovely. Sky's a neighborhood. Thank you for the 5 gifted memberships. Much appreciated. Sin, thank you for the gifted membership. Bees on Mars. It was CNN, but citations matter. And the thing is it could have been CNN or it could have been somewhere else. Like it could have been another source. Sky's a neighborhood. The internet even cites for you. Yeah, it often does. Laura Leanne, assume Kerry got those pictures, got the pick of those rounds from Hancock. I think so, but it was via Teskey. Teskey, I think, was the photographer. Suitors, thank you for the YouTube membership. Much appreciated. Ella, I know you said your discretion. Motion to issue against the tide, the first coin. That, I think, is the plan. Michael Muddragon says, challenge coin idea comes now. Fair. The original Mrs. Rochester, will you cover the ethical disaster happening in Texas bankruptcy court? Judge secretly living with attorney whose law firm he granted $13 million in fees to. He stepped down, but massive fallout. I will have to look into that. That is crazy. CUB says, or Cub says, it's my 40th birthday. Happy to watch Runkle today. Happy to have you here. Lindsay says, how did Hannah Guitierrez have the shells, but Alec Baldwin didn't? I don't know. I'm not actually sure why. And yeah, that's a cocktail. I'll have to try it. Lord knows I made enough paper airplanes in my life. A paper plane is, let's see if I can remember this from memory. It's Aperol. It is bourbon. It is lemon juice, and I think it's something else. What all is in a paper plane? And the thing about a paper plane is that they actually Amaro Nonino is the other ingredient. They taste very, very, very smooth, and they taste kind of like candy. They don't taste like there's much booze in them at all. Lindsay says, I meant, how did Hannah have the evidence, but Baldwin did not? I don't know. It seems that they provided it to one side, not the other. The paper plane is delightful. The problem with the paper plane is that it is 3 kinds of alcohol mixed together with lemon juice, and so they'll get you smashed pretty fast. They have a lot of booze in them. I'm okay. Like I'm fine with that. I'll drink a martini. I like a martini because a martini is, gin vermouth. So yeah. All right. In the alternative, the court should grant Ms. Guitierrez Reed release pending appeal, i.e., let her out on bail while she's waiting for the appeal. And there's going to be one big problem, one big issue that comes up on this one. One huge problem that they try to just kind of play fast and loose. Yeah, this is, there's a place where they're trying to do a little bit of a 3-card Monty, and, yep. In the alternative to an outright dismissal, or at least a new trial, what is it? I am flagging that, Michael J. Money. We'll come back to it. the court should grant Ms. Guitierrez-Reed's already filed motion for immediate release pending appeal. A defendant convicted of a nonviolent offense is entitled to release on bail pending appeal if the court finds two things. One, by clear and convincing evidence that the person is not likely to flee. Oh, hey, Emily sends her regards. Glad to see you guys. I miss Emily. I got to hang out with her a little bit, and I was like, I just kind of wish I lived out in Nashville now. So here's the two criteria for whether or not you can get bail. By clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. And two, that the appeal is not for the purpose of delay and raises a substantial question of law or fact likely to result in a reversal or an order for new trial. Now, I actually think that the second one is fine. They're doing all right on the second one in terms of it raising a substantial issue here. Fair enough, right? The problem, I think, the problem is two issues. One, is she likely to flee? Can they show under clear and convincing evidence that she wouldn't flee? Well, I think that her jailhouse communications are a bit of a problem because she shows that she is not inclined to follow court orders. She indicates that she will refuse to testify if subpoenaed. She indicates basically contempt for the court. And so that's not great. But that's not the worst issue. The worst issue is not the likely to flee. That's not the big one in my mind. The big issue is, how does she show by clear and convincing evidence that she's not going to pose a danger to the safety of any other person or the community if released? Now, here's the thing. I don't think that she is going to pose a danger to the community based on doing more film armoring, right? I don't think that she's going to go out and get another gig on another movie and suddenly she's going to be like the armorer on like the next John Wick film. I just don't see that happening, right? That to me is not happening. Fair enough. We'll exclude that. However, she is charged with sneaking a gun into a bar and then laughing about it in a video where she's like, ha ha, you didn't check sort of interior spaces. You checked the exterior, but not the interior design. So that suggests she's going to pose a danger to the safety of the public. She also talks in her jailhouse calls about how her boyfriend could own a bunch of the guns and she could pretend that she doesn't have access to them. So that makes it very clear that she seems like she wants to get access to guns and that she violates the law with those guns. How do you get to clear and convincing evidence that she's not going to pose a danger to the safety of the community if there's that? So, yep. That's a problem. So, involuntary manslaughter is not enumerated as a violent crime for the purposes of the statute. Moreover, such release is automatic and mandatory upon a finding that the above prerequisites are satisfied. For the reasons discussed above, the first prong is satisfied. What? That's it? It's just for the reasons above? I didn't see any reasons above. that, that the first prong is satisfied. You can't just tell us that it's satisfied without actually providing us some freaking reasons. Tell us reasons. Why reasons? So all that is required is that Ms. Guitierrez Reed's appeal raises a question of more substance that would be necessary to a finding than that it was not frivolous, and that if it were resolved in her favor on appeal, would entitle her to a new trial. I think that she meets the second test. I don't think she meets the first test. I wouldn't let her out pending trial on that, or pending appeal. So, conclusion, for the foregoing reasons, and here is where they're going to throw some shade. They're going to throw some shit at Morrissey without making any argumentation on it. For the foregoing reasons, Ms. Guitierrez Reed respectfully requests this court order a new trial or dismissal of the case for egregious prosecutorial misconduct. The court should also order Ms. Guitierrez's release. Finally, the court should order under its inherent power that Ms. Morrissey be removed as special prosecutor for the misconduct that has been found and the violations committed in Ms. Guitierrez Reed's case. So they also want to kick Morrissey off the trial. And they make no argument about it. It's just like, oh, and also Carthage must be destroyed. Like, that's kind of how they do this. It's just, oh, also kick her off the file, please. That's not how you should do that. That is, you should make an argument. You should argue the issue, not just that. That's not how we do things here. All right. So, chat, I need to know, do you want me to go over the interview that News Nation did with what's her name? Erlinda Johnson. Do you want me to go over that? Is that something you want me to cover today, or not? Because my throat is getting pretty scratchy, and so I'm like, it is, it's rough, but I am willing to do it if chat wants. I see people saying yes. Okay, now I just have to find it again. I had it. Now I just got to find it again. Erlinda Johnson interview. Where is it? Here we go. Full interview. We're just going to pull this up. All right. We're going to go over this. We're going to talk about it. The video quality is awful. We're also going to go through the super chats before we do it. Snowbank Beers, do you have an opinion on how the outcome of a trial could be affected by the fact it is televised versus not as publicly accessible? One thing is that people come out of the woodwork to provide evidence. That is something that we've seen happen. So, and it could affect juries. I don't know if it does, but it could. Michael J. Money, did they have a mutual defense agreement? EDB said they did last Friday, but I've heard others say they didn't. During one of the motions hearings, they specifically said that they didn't. They specifically confirmed no mutual defense agreement. So, yeah. All right. So, yeah, I don't know maybe they misled the court, but they said no. Renee Smitley, love you, Runkle. Thank you so much. Vomit Fountain, thank you for the 10 gifted memberships. Mildred Katie says, I was just in Tuscany and discovered the tradition of aperitivo. My favorite spritz was the Hugo elderflower, and probably the trip is how I got COVID. Fair. That is a classic way to get COVID. My wife and I are planning a camping trip. And yeah. Did you hear whispers that Alec Baldwin was maybe wanting to sue the prosecution? That'll be interesting. I don't know if he'll have any success, but that would be interesting. Somebody said she was added to the Brady list. Okay, that's interesting. I am going to try to check the Brady list. 1 second. Let's just see. So it looks like there's a Brady list for New Mexico. It also looks like the it also looks like the Brady list for New Mexico has me blocked. I can't access it. Let me, I can show you what it shows. I can show you what it comes up with. There's a site somebody was showing me as like, here's the Brady list available online. Let me show you what it shows me. Sorry, you have been blocked. So I think that's because I'm coming to them as a Canadian, and they're like, why would a Canadian want access to this? Now, I tried it as well from a VPN using an American IP, and then I get blocked because I think it says, hey, why are you using a VPN? So the VPN doesn't work. Not using a VPN doesn't work. So I just can't read it. I will probably try to figure that out later. All right, let me adjust my audio so that we can get this presented. And I'm just going to say this interview is obnoxious because Chris Cuomo's channel is the worst to watch that I've ever seen. It is so god awful. Let me just adjust the audio. Okay, hopefully you guys will be able to hear this when it comes on, and we will just add this to the stage. I'm just going to hide myself for a second. So this is the busiest BS that you have ever seen on a I just hate seeing all this. Like, just show me what you're talking about. Don't show me all this all this crap on the screen. Like, is there any room for you guys? Like, just show us the interview people, not this giant chyron on the bottom and all of that. Like, that is obnoxious. But let's go on there. I see people saying Erlinda Johnson is also on the list with Carrie Morrissey. Okay. Interesting. All right, let's have a look here. So I see somebody saying try going in private mode. Maybe we'll see. So let's have a look here.
Hi, Chris.
First, let me give you a chance to respond what was said about you. Another member of the team said you left the team because you didn't like that this Brady hearing was public.
Absolutely not. Absolutely not. I left because I learned about this evidence when the public learned about it yesterday, late afternoon. I don't know if you're aware, I actually came on this case kind of late in the game. I came on the case.
Okay, so here's the thing. They have a different take on things, and I kind of so I kind of think ultimately that that they each have a different view of things, and the so Erlinda Johnson left, in my view. Erlinda Johnson left because she what is it? So I'm just trying to see. Erlinda Johnson left because she didn't want to have the hearing, right? She just wanted to withdraw it, right? Which is correct when you say that she didn't want to have a public hearing. Carrie Morrissey did want to have the hearing, which of course is a public hearing. And I don't think that Carrie Morrissey was arguing that the case should go on. Carrie Morrissey very clearly realized that the case shouldn't go on. I actually believe that this is a legitimate, that they have a disagreement as to as to things. So I do see somebody sent me an image of, Carrie Morrissey and Erlinda Johnson on the Brady list. I wish I could like browse through and see what details they put up. I wish I could see if Popple and Hancock have been added to it, because Popple and Hancock definitely should have been added. If they just added the defense lawyers, not the police officers, that's an issue. So I think that they got their wires crossed a bit. I'm not going to call either of them a liar here. I'm not going to call, and I suspect, I don't know for certain, I suspect that the reason why Morrissey had that hearing was to make sure that Hancock and Popple got dragged out in front of the public. I suspect that's why. So, yeah. I do have a VPN, and it's just not working. The VPN gets blocked as well. So, yeah.
Towards the end of April. So I had to get up to speed. I was not involved in the Hannah Guitierrez case at all. And so I was not aware that this individual had taken this ammunition to the sheriff's department and provided it to the officers. I learned all of that yesterday when Mr. Spiro was cross-examining the crime scene technician. So I inquired some more. And this morning when
who the hell, like whoever it is that sets up this visual nightmare, they need to be fired and then also hit with a stick. Kat, the thing is that Morrissey didn't even ask the court not to throw it out. She made no submissions on that. She made no submissions on that. So I'm just going to note, there is a case that we will go over on a Monday. There is a case that we're going to go over on Monday, a Canadian case that we're going to cover as part of Monday Fun Day. And the Monday Fun Day case involves that a lawyer is getting a 6-month suspension for punching an articling student in the groin. So I think that might be an appropriate step to take for whoever generated this visual bullshit. Because, like, why is Morrissey on the screen? We want to see the interviewer. We want to see Erlinda. That's what we want to see. Not, like, why is most of the screen occupied by the person you're not talking to? Christ.
The motion hearing began, my position was during the lunch hour, before the lunch hour, during the lunch hour, we have an obligation as prosecutors. We have an obligation not only to the people, but to the defendant. Mm-hmm. And our obligation is to make sure that all the evidence is turned over.
And this I agree with 100%. I just think that Carrie Morrissey and Erlinda Johnson both realized that the case was dead and should properly be dead, right? That they both realized that this should end, right? And the thing is that they had a different approach as to how to end it. Erlinda Johnson was like, we could just like dismiss this. Like we could just invite dismissal. Whereas Carrie Morrissey was like, we need to actually, like, we need to have a hearing on this and get, and get heard. So, yeah, this is, this I think is a difference of opinion. I don't think either of them actually thought that this was going to go on. I'm just looking at this. The more I look at this, the more I hate it. We've got Cuomo's name all across the top here. We've got Cuomo's name in the bottom. I'm not this full of myself.
We don't get to decide what the defense is going to be.
Why is the
Our
Cuomo
job
name
is to
moving?
ensure transparency and to ensure that the defense.
There's all these moving Cuomo names, and I'm like, oh my God, stop it. Are you that important?
Defendant has everything that the prosecution has gathered.
Yes, that should
What they
be
do
the
with
case.
it, that's up to them. Go ahead.
Two things. One,
Sure.
the better minds that I bring on the show, because what do I know? We're
I'm just gonna say I don't much care for Cuomo here.
very impressed by your opening. They
Yes, that
felt
is true.
You had good command.
It
and
was
that
a
you made
great
a very
opening.
strong case. Did you believe that Alec Baldwin should be found guilty?
I did. I believed the evidence that we had. I had.
And the thing is if they didn't believe that the evidence was towards guilt, they wouldn't have run the trial, right? They wouldn't have run the trial. The other thing, holy crap. I'm just going to note. So my, I don't have a video. I kind of feel like I need to take a picture of my view from this direction. But what I'm just going to note here, is that in terms of where my camera is, like this is level, my camera is up. My camera's up. There are two directions that it is acceptable to have your camera coming at you from. Direction number one is dead on level with your eyes. Dead on level. That's acceptable. The next direction is above you, looking down. Where you should never, ever, ever, ever have your camera is below you. Below you is a terrible, terrible angle because now we've got nostril cam. Nostril cam is like, don't do nostril cam. My audio video setup is less than $500. It is not a good audio video setup. I want to replace it. I want to get a better camera. My mic is okay. I want to get a better camera. I need to get a better camera. So, but I have a crappy discount setup and it's better than this. Like she could get this, she could improve her setup for like no money. Erlinda Johnson, if you're watching this, call me. I will set you, like, I'll get you a better setup. Do not nostril cam ever, ever, ever for any reason. No nostril cam. No. So, no.
No idea that there was this other evidence that had not been turned over. That there were some actions that were done during the filming, and there was some recklessness.
Yes, send that to me
if
you got it.
Based on the evidence that was available. But my job is not to get a conviction, it's to put the evidence before a jury. That's how I saw my job, is to put up.
Absolutely. And you know what? I have had Crown prosecutors. I've had Crown prosecutors dismiss the case. I need a mirrorless camera, the lens that has a good depth of field, and an HDMI USB adapter. I just don't know anything about cameras. I need to go to a camera store and be like, hey, here's what I need. Maybe I'll do that tomorrow. Camera store, Edmonton. Now I'm getting distracted. So I'm just going to tell you that I had a trial at one point, and at the trial we did the whole trial, and at the end of it, the prosecutor told me, he said, I don't think the judge is going to convict. And I was like, you should just invite dismissal. He's like, I don't know. I don't know. So I was like, you should dismiss. And he's like, I I don't know, like maybe he was being kind of wishy-washy, and I kind of thought that was crappy, but it is what it is. And then we were both surprised. We were both stunned because the judge convicted. And so he's like, so what are we doing about sentencing? Are we doing sentencing now, or are we doing sentencing later? And the prosecutor, to his immense credit, said, Your Honor, the Crown directs the stay of proceedings, which is basically that kills the file. Because the Crown prosecutor said, I did not think that your client should have been convicted. Once the judge, and he said after the judge said he convicted, that he's like, no, this is the wrong decision. This is the wrong call. So he dismissed the charges. I had another one. So Logitech 4K Pro, that is exactly what I'm using, and it's not fantastic. Not fantastic. So we had I had another trial where the prosecutor, we ran the trial, and it came time to closing submissions, and the prosecutor just said, Crown's position is that the court must acquit. And the judge was like, I think I should acquit, or I think I should convict. The prosecutor was like, nope, you should acquit. So the judge eventually ended up acquitting as a result of that. Because the prosecutor said to me afterwards, he said, you did a great job in there. And by the time we got to the end of it, by the time we got to the conclusion of this, I was convinced that your client should be acquitted. I no longer had a belief in the conviction. So I was thinking, okay, great, fantastic. So that is exactly it. You put it to the jury, you put your best case to the jury, and the jury makes the call. But it's not your job to force a conviction.
All this evidence before the jury and let the
Prime
jury
Day is
decide.
today? What?
But once things start,
why do you have silent trial on? Ugh.
oh, go ahead. Sorry.
No. I want to hear you. But once things what?
So once I learned that this evidence was not turned over, that it was there, it was under a different case number, and my obligations, my ethical obligations as a prosecutor. Now, keep in mind, I've been a prosecutor. I was a state and federal prosecutor for over a decade. I've been a prosecutor. I've been a criminal defense lawyer for the last 16 years. So I've been on both sides. And I know what you're required to do. And when this came to light,
I mean, defense lawyers would know that as well.
Best decision would have been for the state to dismiss the case.
And the thing is that dismissing it does avoid the public hearing. That's kind of the issue there, is like, do we have the public hearing or not? So that's kind of what the argument was about, right? So, okay.
That's why I resigned.
Really?
Because I believed that case should have been dismissed. And I advocated for that over the lunch hour, and it wasn't. And so when we came back after the lunch hour, I asked to withdraw.
And we do see she asked to withdraw. And then immediately after the request to withdraw, Morrissey starts basically humiliating humiliating everyone else. So, yeah.
So you wanted the prosecution team to walk away from the case. They said no. So you said, then I'm walking away. And then the judge basically agreed with you. So I have two questions. First one is, so you believed it should be dismissed. Explain to people who don't understand anything about the law, why did you believe this ammunition was so important for the defense?
I mean, I don't know that it is super important, but okay, we'll see.
So obviously, you're a lawyer, I think.
I'm
Brady
willing to
versus
spend some
Maryland
money.
imposes requirements on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well.
This is basically the thing of, even if you don't think it's going to change the case, the defense is required to get that evidence so that they can decide, right? Because sometimes the prosecution will be wrong about that. Sometimes the prosecution will absolutely be wrong. And here's the thing. I think that Erlinda Johnson is acting in an incredibly ethical way here. I have absolutely, I give her tremendous credit for her ethics here. However, I'm also glad that Carrie Morrissey made those two testify, because I wouldn't have known exactly how bad it was until Carrie Morrissey put those two up on the stand. I don't know. I really, really, really want to. I really, really, really want to. I wish I could interview Carrie Morrissey. I really, really wish I could talk to her and just be like, what was your goal here? Were you trying to save the case, or were you trying to put this out into the public? Because if she was trying to put this out into the public, what Carrie Morrissey did was kind of heroic, in the sense that she ended up throwing herself all the way under the bus. We'll see.
So is the evidence material? That's number one. How timely is the disclosure? Without question, this was grossly untimely.
Yes,
number two,
absolutely.
is it material? So the question is, could the defense have made some use of this evidence in their defense? And like I said, we as prosecutors do not get to make that decision, what the defense is going to.
Yes, that is exactly it. The example I gave elsewhere is, let's say the prosecution, let's say there's a case where there's a murder at a, and I'm going to embiggen myself here just while I go through the example. Let's say there's a murder at a, let's say there's a murder that takes place at a truck stop, right? Truck stop murder. And so at this truck stop murder, the prosecution finds a bunch of cigarettes with DNA on them, and also an empty cigarette package. And from that cigarette package, they're able to determine that cigarette package was purchased a month prior to the murder, a whole month before the murder. And they match the DNA to the guy they see buying the tickets or buying this cigarette package. They also show that this guy has no criminal record. And they say, okay, this guy isn't our guy because he bought these cigarettes a month before the murder. So often before the murder, right? Or so early before the murder. So it can't possibly be this guy. So they say, because of this, we're not going to turn it over to the defense. And yeah, then you have the defense going, okay, we never hear about this. And you might say, that doesn't matter, right? That, like, who cares? But let's imagine that they do turn it over to the defense, right? They do turn this information over to the defense, and the defense has Baldwin money. The defense is able to do some real looking into this. And what they find, looking into this, is that this guy ends up, it turns out that he works here and he lives here, but for some reason he's at this rest stop that is like way out of the way of both of those places. That's unusual. Why is he there? There's no reason for him to be there. And it turns out that not only was he there that time a month prior, but he was there every few days up until the murder. He was there for an entire month, stopping in, stopping over. And then after the murder, he never goes back again, right? Now we have a situation where this is the cigarette butts that we thought were completely unimportant, that these things were completely uninteresting, turn out to be absolutely 100% critical, right? And we go, now it sounds like, this guy might have been staking out this rest stop to maybe murder somebody there. This also is not entirely correct. It says, I think Carey's getting too much credit. According to Popple and Hancock, Carey directed them to hide the evidence. Popple didn't say that. Hancock says that. Popple did not say that. So Popple and Hancock are different on that point. All right, let's keep going here.
It's, can the defense use this?
Why do they, we want to hear this person. We want to hear Hancock. Why is there more video space taken up with the bullets?
And could it potentially raise some sort of reasonable doubt? And you have to step back. You're not an advocate. As a prosecutor, you're not an advocate. You are there to present the facts and to present the evidence. And your job is, and that's why I took this case on. I agreed to come on board, is because there was a woman who was killed. No question about it. This was tragic. And something happened. And a jury needed to make that decision. And so I believe in the system. And unfortunately, something went horribly wrong here, and I was not aware of it. And when I did become aware of it, my ethical obligations dictated that I advocate for a dismissal.
I got no problems with Erlinda Johnson. I want to hear from Morrissey as to what her motives are. I don't know her motives. I can guess. I can speculate. I can think of what I would have done in her shoes. I can think of all of those things, but I don't know for certain. I don't know. And I 100%, I think Erlinda Johnson is an absolute, she did the ethical thing, right? She was fantastic, but I want to talk to Morrissey.
So let's talk about what went wrong, okay? And you guys at home can Google Brady versus Maryland. It's a 1963 case that basically just goes to things that either could be exculpatory, meaning it's evidence that the defense could use to show it wasn't them, or what they call impeachment, which is evidence that the defense could use to show that one of the witnesses for the prosecution is full of it. Okay, basically that's what Brady was. They call it Brady material. Your co-counsel says you have it wrong, that this ammunition, she knew about it, obviously, and she says, nah, it didn't have any real value. It had no resemblance to the ammunition that...
Why is he why isn't he asking her the questions? Why wouldn't he ask her what Brady material is? Come on, dude.
Is involved in Alec Baldwin's case. Why would I turn it over?
Well, at the end of the day, a jury could have believed that, but our obligations are to turn all evidence over that could potentially be used by the defense in their defense. It's not for us to decide what is the defense going to be.
Correct.
It's not for us to say, well, his defense was he didn't pull the trigger. So his defense is not.
I got you. But here's the tough question. The suggestion, not from you, from me, is that this may have been in bad faith. Your co-counsel knew about this. She was willing to get on the stand, take the oath, and say, I didn't see any value here. Defense counsel and you echo the same standard. You don't get to decide whether or not it has value. She says, yes, I do. Otherwise, how do I know what to turn over? And I thought this didn't meet the standard. What is the standard, and why do you believe co-counsel got it wrong?
Well,
I really don't like his tone. I really don't like his tone at all here, but okay.
I mean, this is a lot to process. Obviously, I learned about this yesterday evening. But just in looking at, so the first time I look at this evidence was this morning, because it was brought over to court. I think, as you saw, the judge had them open the envelope. And so there were 3 rounds that looked very similar to the live rounds that were found on the set of Rust. If, thinking as a defense attorney, I'm thinking the defense could have argued Hannah Guitierrez-Reed was a great armorer. She was completely competent, and there was sabotage. So you have that potential sabotage.
Okay, I'm going to disagree with you, because if she is a great, if she's a great armorer, then the sabotage would have been caught. And not just if she was a great armorer. If she is a competent armorer, then even if she is a bad but technically tolerable armorer, then that sabotage should have been caught. Like, if she is anything short of wildly incompetent as an armorer, but yeah, I mean, the defense could have said that she's a great armorer. I'm just like, nope, that still gets you to awful.
Angle. So then at that point, potentially those 3 rounds do become potentially exculpatory. But the point is, it should have been turned over. It wasn't turned over.
So
and
you think it met the standard? Any way you look at it, it should have been turned over. It was enough for you to step away.
Yes, she said that like 7 times, dude.
I want to ask you about the case now that it's dismissed, because I didn't understand why you guys brought it. I thought it was totally political. I thought if this guy's name wasn't Alec Baldwin, if it was Alec McIntosh, he wouldn't be there.
Yeah, no shit, he wouldn't be there if it was Alec McIntosh, because Alec McIntosh would not have been in a position to be the lead actor on the set of Rust. Like, no kidding, Alec McIntosh is not the lead actor on Rust. Cool, right? Good on you, I guess. Yeah.
Pissed off the prosecutors early on by what he was saying, and they wanted to get him. Why am I wrong?
well,
The thing is any random idiot, any random jackass who points a gun at a person and thereby kills them, you would expect that they would face charges. If I as Ian Runkle, if I went and pointed a gun at, any random person and pulled a trigger and they died, then yes, I would face charges. And I will say, under the Canadian standard, the Canadian legal standard, Baldwin's conviction would have been virtually certain. Virtually certain, assuming no prosecutorial shenanigans. Virtually certain, because the Canadian standard basically says you cannot ever abdicate your responsibility for how you operate a firearm. You just do not have that ability. Full stop, period, ever. And if you don't know how to use a gun, that your responsibility, your obligation is to learn how to use a gun before you handle it, at least to the point of safety. You can't say, I was relying on someone else, I don't know what to do with it. You are required to behave safely. And the main difference between Baldwin and some random jackanape is that some random jackanape would have would not have had the money to defend this the way that they did. So, yep.
First of all, I was not involved in the charging decisions. I will tell you that based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some force.
Yeah, Baldwin was being incredibly unsafe with the guns. Baldwin was an accident waiting to happen. He just needed Hannah to make it happen. Like, Baldwin and Hannah together, I don't think, I mean, I am fine if neither Baldwin nor Hannah ever touches a gun again anywhere. And I just want to say, I am pretty pro-gun, right? I am really pro-gun. And you're wondering, like, how pro-gun are you, Runkle? I am sufficiently pro-gun that I think that if a woman walks into court and says, hey, I need a restraining order, the court should also have the authority to provide her with a temporary firearms license and a temporary carry permit. And the temporary is to the extent of you are expected to go and apply for that firearm license and carry permit to make it permanent. But, like, woman comes in and says, my ex wants to kill me. I'm like, cool, have a gun. Because the piece of paper won't necessarily solve it. And let's make sure that if he does come by to kill you, that you can kill him first. That's how pro-gun I am, right? Like, let's make sure that happens. She'd have to get training afterwards. She'd have like 3 months to go in and take the training. And I think that training should be free if she's in that emergency situation. But absolutely, I believe in like an emergency, thing. You get the gun today. And, within the next 3 months, you've got to book a course. And there should be a process for that. So, yeah. Claude Simeon, we'll get to that. We're going to go through this interview. I will get to questions. So, yeah.
Play with this gun. For example, one individual who was interviewed by the OSHA investigators and testified or gave an interview that there was a time that he allowed Mr. Baldwin to use him kind of as a target to shoot blanks at him, at his person. And obviously, these are real guns. You don't do that with real guns.
Correct.
So there's
on a movie set?
You don't shoot blanks at real people on a movie set. In that, like, he's saying on a movie set? Yes, on a movie set. You don't fire a blank in any situation other than where it is called for by the filming and specifically permitted or authorized by the armorer. Absolutely you don't. No. Are you crazy? No, you don't. So, yeah.
But isn't that exactly what they do on a movie set?
Well, no, you don't use another person as a target, as a human target. So that could potentially be reckless. And so, he wasn't charged with intentional homicide. There's no question.
He's charged with a crime of
there's
recklessness.
No question Mr. Baldwin did not intend to do this. But the question is, was there wanton and recklessness? And
yes.
So that's why I did believe in the case. I had no idea that this other evidence had not been turned over.
That is very clear. And I've told the audience, this is not about you. That's a separate prosecutor who seemed to know about it. We've showed her on screen. Her name is Morrissey. It is not you.
I was like, are they not going to name her? They're just going to hint. But no, they did actually get around to calling her, like to identifying who she is. Okay, cool.
I just want to ask you, I have two more questions. The first one is, I still don't buy it. I don't understand how on a movie set, you should have a reasonable expectation that you might have live ammo in the weapon. Well, why?
This is the better argument, is like he could, and this is the argument that I would run. Like, if Baldwin goes to trial and I'm his defense lawyers, I would be arguing this. I'd be saying, like, when has there ever been live ammo on a movie set? When does this happen? But yeah, I mean, like, okay.
Hey, why would you have that as a reasonable expectation?
I'm also just going to say, and I feel like I'm going to be a bit of a jackass when I say it, I feel like there's a lot of people whose positions on this are partially informed by their financial interest. I've seen a lot of people who are like, it would be real bad if Baldwin was convicted based on it will potentially put people out of work. And I'm like, that is not an argument as to whether or not Baldwin should be convicted. I also wonder if some people are not taking certain positions based on a hope of cozying up to Hollywood. So I kind of wonder that. Yeah.
Because remember, there are the SAG guidelines, there's bulletins, safety bulletins that dictate even if you're an actor, even if you're on a movie set, you treat a live.
The movie industry cannot set a lower standard of care than exists anywhere else. They just don't have that power. As powerful as Hollywood is, they can't say, oh, we are creating a law-free zone. They don't get to do that.
A real firearm as though it's always loaded, never pointed at another person, and don't put your finger on the trigger until you're ready to shoot. Those are cardinal firearm handling safety rules. So yes, did I believe that there was some inappropriate behavior with regard to handling this gun? I do. It's unfortunate that things went the way they went, but the fact of the matter is that we as prosecutors have very, very serious and high ethical obligations that when something comes to our
Absolutely
attention,
they do.
Evidence comes to us, or we become aware of evidence, you turn it over.
Yes.
You don't decide.
Are you a big Alec Baldwin fan? Are you a big Alec Baldwin fan?
Who the F cares? Like, this is the thing, is I've had people, there's some person on Twitter who's like, you just hate Alec Baldwin. It's like, I don't care about Alec Baldwin. I didn't look up Alec Baldwin. Like, the last Alec Baldwin movies I watched literally were like The Hunt for Red October and Beetlejuice. I can't remember what he's been in since then. Since then, right? I don't know, right? I don't. People are like, you didn't like him on Saturday Night Live. I'm like, I didn't watch him on Saturday Night Live. I don't freaking. Okay, I care a little bit about who is. Oh, was he in The Departed? I didn't remember that he was in The Departed, but I guess. The Departed was a great movie. I just didn't remember that he was in it. I don't really care about Trump other than how he's going to affect Canada, because it's not really my place. I certainly don't love Trump. I think that the U.S. deserves better political candidates than it's got. I think Trump is awful. I think Biden is awful. I think every single person is awful. But I also think all of the politicians in Canada are awful. I just don't like politicians, but that doesn't mean that I think he's guilty of anything. So, like, my analysis has nothing to do with Baldwin, and the fact that he made fun of a politician, any politician, is a point in favor, because every single politician out there, every last one of them, no matter how much you love them or hate them, deserves to be mocked at every turn so that they don't think that they're gods. Absolutely, we need to make fun of them. So that's a point in his favor. Like, Baldwin, good on you. Like, this whole notion of like, you know, oh, you just like, no, fuck's sakes, make fun of politicians, please.
You know, I actually do. I am a fan. I wouldn't say a big fan. I did, and I never saw him as Alec Baldwin, the actor. To me, it was this.
This was the other thing with the Depp trial, because everyone's like, "Oh, you just love Depp's movies." I'm like, I like Edward Scissorhands, and what else? I watched the first Pirates movie. I didn't watch any of the others. I watched the first Pirates of the Caribbean. It's like I don't know. Like, I just don't watch a lot of film. I don't have time. Like, I just usually I watch like TV shows with my wife. I watch them like we'll watch them like 3 at a time on date nights. And we don't usually watch movies because it's like a movie is like a 2.5 hour commitment. Whereas instead we'll watch 3 half-hour episodes, and that's like an hour and a half. I just don't have the time in my life to any of this. What's Eating Gilbert Grape? Didn't see it. Nightmare on Elm Street. I saw part of it as a kid. I just don't know any of this.
This is a case. Someone died. This was a tragic case. Someone was killed. And,
yes.
And she was killed with a live bullet. She was killed because someone also pointed a gun at her. I never had, for me, it was not about Alec Baldwin, the actor. This is not about politics for me. It was about putting forth the facts before a jury.
Absolutely. Let the jury
last
decide.
Thing for you. And again, really, thank you for coming on, Ms. Johnson. Really appreciate it. You ooze authenticity to me, and we are very hungry for it right now when it comes to trusting our institutions. So I appreciate what you did. But I'm also worried for you.
Never watched it.
Are you worried that, you know, the right move was for you to just kind of sit there and let the judge make the ruling, and then if they made the wrong ruling, you could have walked away, but now you walked away and you may be a target in the community or by other prosecutors for going bad on your team?
She's a defense lawyer, dude. What does she care about? What does she care about if prosecutors don't like her? She's a freaking defense lawyer. You absolute, like, this guy's a neck and a hairstyle and everything in between you can just discard. Oh my God. She's a defense lawyer. What does she care if prosecutors don't like her? Like, why would she care?
Well, no, I walked away before the judge made the ruling. I asked you.
I know. Should you have waited?
No, absolutely not.
Should you have waited? And she's like, if I should have waited, I would have waited, you dumbass.
Have ethical obligations. And personally, I have moral obligations. And my ethical obligation and my moral obligations really are not that different. And
I actually think that Carrie Morrissey and Erlinda Johnson both thought that they were being ethical. I just think that they had a very strong disagreement as to what ethical meant. And you know what? Absolutely, she made the right call. And if she thought that her obligation, like, here's the thing, if she thought her obligation was to get out of the trial, absolutely she should. I am not, like, even though I am glad that we heard all of these details, I do not fault Erlinda Johnson in the slightest. Not an iota. She is good.
And so when I see that something isn't right, and when I see that the law isn't followed, I don't care who you are, where you are.
Yes.
You make the right decision. And for me, the right decision was to walk up to the judge and asked to be allowed to withdraw before that circus of a hearing got underway.
And here's the thing, the circus of a hearing, in my view, and this is my opinion, the circus of a hearing was a public good. It was a public good that we got to hear about that. Because if we hadn't gotten to hear about that, a lot more people, when I say that it is the right and the correct and the just result that that Baldwin was acquitted, even though I was in favor of the prosecution. When I say that it is a just result, I would have so many more people pushing back at me if we hadn't gotten to see and hear those details. I am glad that we heard it. I think it is a public service. It's a public good that we got to hear it. And even if Morrissey's motivations were bad, maybe they were, maybe they weren't, but I am glad it happened. I'm glad it happened. So, yep. Runkle of the Bailey, about emergency gun permits. During my divorce, ex violated the TPO 40 times, including on video stealing the camera I hid, catching him at my house. Judge called me a liar while the state prosecuted. That's the thing. It gets to be a mess.
You think that she decided the way she did because of you?
No, absolutely not.
That's a stupid question.
Absolutely not. I think that
I got to tell you.
No, you got to let her.
No,
you don't got to tell her shit. You got to let her finish her point. Like, you got to not interrupt her. You asked her a question. Have the respect to let her answer it.
I said, I think it's because it met the legal standard.
I got to tell you, Erlinda Johnson.
You don't got to tell her
this
shit.
Is a very refreshing conversation. It has nothing to do with the outcome of the case. I
got to say, I liked half of this conversation. It's like the right, it's the right half of the conversation. Yeah.
Still don't get the case, but I respect your argument on it. And I really respect what you did and your rationale for doing it. This was a brave thing to do. And I have tremendous respect for you. And if there's any...
The thing is it's brave, but it's also... it is also the easiest course. I will say that it is way... like, getting off the record is almost always... The ethical course is almost always the easier path. If you have foresight, the ethical course is the easy course. So no shit, it's brave, but it's also not, if that makes any sense at all. I don't know if I'm explaining that right, but yeah.
Anything we can do down the road to help if this gets a little ugly because people don't like what you did?
What the hell are you going to do to help? You going to, like, you know, show up with a carry permit if people are angry? Like, anything we can do to help. What are you going to do to help? You going to, like, shovel or walk?
We're a call away if we can help in any way. But thank you for rationalizing your behavior the way you did.
No problem. Thanks for having me on.
Hey, thank you.
Okay, so we get rid of that guy because I don't like that. I did not like the I did not super like that. So apparently there's a Court TV interview.
Court also.
Whoop! I'm just trying to see if there's a. Oh, there is. We're gonna watch the Court TV interview and we're gonna comment on it because, you know, I hope it's better. It'd be hard to be worse. We're just gonna do this. Okay.
I want to welcome in Special Prosecutor Erlinda Johnson. Erlinda, good morning to you. Thank you for being with us. Good morning. Start, please, with why you resigned. Would you share with us the reasons behind it, please?
Absolutely. as you, I think,
Oh God, the audio is miserable, but okay.
all heard on Thursday evening or Thursday afternoon, Mr. Spiro, Mr. Baldwin's lead defense counsel, cross-examined the crime scene technician about this ammunition that had not been turned over or made available to the defense.
Yep.
And that's the first time I learned of the existence of this ammunition that had been tagged in under a separate case number.
And I 100% believe her here. Like, I 100% believe her when she says this. I think she's being honest. I think she's being accurate. I actually think Erlinda Johnson has been entirely honest through this whole procedure and entirely ethical. If I ever teach, so there's a class I want to teach. There's a class I really want to teach in law school, and I'm going to pitch it to the law school. And the class is basically, let's watch trials. Let's watch as much of court hearings as we can. And we're going to have to watch a bunch of American trials to do this. And we're going to learn. We're going to learn ethics. We're going to learn advocacy. We're going to learn like how to do things by watching trials. I would 100% run Erlinda Johnson's decision and be like, let's talk about the ethics of this. Let's discuss this. Let's talk about the ethics of Ms. Morrissey. Let's discuss this. 100% we'll have a discussion. I think that this is a lot to go over.
Then on Friday morning, when we show up to court and the court ordered that the ammunition be brought into the courtroom, if you recall, the judge dramatically opened this envelope and
why again is there like court TV? Come on. Why is there so much screen bullshit? Show us the person who's talking. All of this other crap we don't need to see. I don't need the court stuff. I love Court TV. They do great video feeds. They're really patient. Court TV is wonderful, but oh my God, why is the person talking getting a third of the screen and not the entire screen?
these bullets started being taken out of the envelope and categorized by the type of ammunition, according to the report that was tagged in under or submitted under a separate case number. 3 of the rounds appeared similar to the rounds that were found on the set of rust. And so at that point, in my mind, this hasn't been turned over. This hasn't been made available to the defense. The state hasn't done anything with this. And I believe that at that point, the right thing to do would have been to dismiss this case.
Tell us what you did once you learned about this in the testimony, when many Americans learned about it. What did you do?
I mean, we already saw this.
I inquired. First of all, I asked, who is Troy Teskey? I was asking my co-counsel, I was asking the detective, who is this individual? And when we recessed, it was explained to me, well, these rounds were not similar to the ones found on set, and they were different. And the question was, why wasn't it made available to the defense? And that's a question I kept asking.
It's a reasonable question.
The belief was these were irrelevant. These were irrelevant because they had nothing to do. They didn't look like the ones on set.
And here's the thing. The prosecution shouldn't be the people deciding that. Yeah.
And I'm not sure my co-counsel had even looked at these physically. She looked at some photographs.
And she hadn't. This is the thing. A lot of people were saying like, oh, you know, why doesn't, like, she hadn't looked at them. That is a critical point.
And then on Friday morning, when we arrived in court and actually looked at the evidence, and looked at the rounds, 3 of them, as I said, appeared similar to the ones that had been found on set.
And that's a big deal.
At that point, did you tell Carrie Morrissey that we should withdraw the charges?
You already know this.
I did. As if you recall, the judge excused the jury for the day. We requested breaks. We all conferred. My reaction was, I think we should walk in there and move to dismiss.
And
because
I mean, that's a perfectly
violation.
legitimate point. I agree.
And keep in mind, I mean, this was, I believed in this case. I believe that there was reckless conduct on set.
Yes.
A woman lost her life. A woman was killed.
Yep.
But at the same time.
And the thing is, I have seen prosecutors who are 100% the most ethical people. I have seen prosecutors dismiss charges. I have seen murder trials dismissed. I have seen trials for child abuse dismissed. I have seen charges for possession of tremendous quantities of drugs, like kilograms, dismissed by prosecutors. I'm not going to say these were all my cases because they weren't. In situations where the police especially have violated people's rights. And absolutely.
I took my job as a prosecutor very seriously. And
yes.
Evidence has to be turned over. We don't get to dictate what the defense is going to be. If it's material, potentially material, if it could assist in raising potentially reasonable doubt or impeachment of witnesses.
Yep.
It has to be turned over.
Erlinda, you're exactly right. So when you told her what should be done, what was Carrie Morrissey's response then?
She wanted to think about it. And then I believe in the end, what she wanted was to just put all the facts in front of the court, in front of the public, how these rounds came to be, how it all transpired, how the state did not believe that this was relevant. And it is possible it may not have been relevant. And the jury could have just disregarded that.
This is the fundamental point, is it should have been up to the defense whether they want to run it, and then it should have been up to the jury whether they think this matters. I agree with her. But I'm glad we saw it.
But it needed to be provided, and it needed to be litigated in court, whether that was going to be introduced or used. The point is, it wasn't provided. That was my issue.
And you were right to have that issue ethically. Oh, please go ahead.
Okay, I don't like this interviewer either. I didn't like Chris Cuomo because he's interrupting to talk about how much he's important. I don't know who this is this Julie? Is this the person who blocked me? If it is, I don't like how she keeps interrupting to blow smoke up Erlinda. We know she's awesome. You don't need to you don't need to play. She feels like one of those guys that shitty rappers have, where there's the shitty guy who's following them up, who's trying to big them up the whole time. Quit blowing smoke. We already know she's awesome.
I didn't mean to interrupt you.
No. Sorry.
It's okay.
No, and in the end, when we came back after lunch, I sat there and I thought, this isn't right. This just is not right. This should be dismissed on the state's motion, and it's not. And so that's when I approached and asked to withdraw.
And I think that that's an entirely reasonable position. 100% got no problem with it.
You upheld your ethical duties as a special prosecutor, and the judge obviously granted your request to withdraw. And we all learned about it, as you know, when Carrie Morrissey made the decision to testify, and Mr. Spiro crossed her on it. And when she was asked about the reason why you withdrew, she said, and I'm paraphrasing here, I don't know her exact words, but it was something to the effect of, well, it's my understanding.
Maybe you should know your exact words if you wanted to be an interviewer today. You came here to do one job, which was to be an interviewer today. Maybe knowing the exact words would have been helpful.
That Ms. Johnson didn't agree with having this hearing here today. now hearing what you're saying, that doesn't seem like it was an accurate representation of why you withdrew.
That's correct. In fact, if I remember correctly, I wasn't watching. I was told afterwards that she said the reason I withdrew is because I didn't agree to a public hearing on the motion, which was not accurate. I didn't agree with going forward with the hearing.
She didn't agree with any hearing. That's the thing. She didn't want any hearing, public or private.
My belief, my thinking was the state should do the right thing and go in there and file a motion to dismiss. It is unfortunate. It was unfortunate for Helena Hutchinson's family.
It's a reasonable view. I just, I'm glad we got to see it. So, yeah.
But the defendant has rights and the defendant's entitled to due process and to have all 100%. The evidence disclosed.
You're spot on. You're spot on, upholding your duty and the oath that you take when you serve as a prosecutor. And you're exactly right. It wasn't for her to decide. It should have been turned over. And as you said, then it's for the jury to decide and defense counsel to choose to do with it what they will. Speaking of the defense.
Okay, you're an interviewer. You're talking way too much right now.
Case. You said earlier you believe in the case, in the prosecution. Curious what you thought of the court's decision to dismiss with prejudice, because we know the judge had the option to just declare a mistrial, postpone the case, say maybe 90 days, allow time for testing, allow time to regroup, set a step.
No, obviously not. You're mid-trial. You're not doing a continuance mid-trial. Like, just say, why couldn't, like, just ask the person you're interviewing, why couldn't we do a continuance? Why is that inappropriate? So, yeah.
Status conference and then push it out for trial at another date. Did you agree that dismissal with prejudice was the right remedy?
Yes, obvious.
You know, at that...
She's only said that about 8 times. Come on.
Point, I think that obviously, as we all know, jeopardy had attached. She could have declared a mistrial with manifest necessity, but unfortunately, there had been previous issues, and this one was in the middle of a trial.
Yes, that's...
I think for the judge, that was just too much.
Sure.
And it was too much for you, too. Like you can say it was too much for you, too. Absolutely, it was too much for you, too, because, you know, just stand up and say it.
Speaking of too much, you know, there was a strong reaction from many trial watchers watching Carrie Morrissey. That was certainly something we don't see every day, where a prosecutor calls themselves and gives an...
Yeah, we said that was stupid. We said that she should have listened to the judge and been like, no.
Narrative, and then is cross-examined. What did you think of her decision to do that?
I thought that was ill-advised.
Ill-advised is a very, very generous way of saying it, because I would say ill-advised is a way of saying it. Ill-advised is one way of phrasing it. The other way you can phrase that is just freaking dumb. Freaking dumb is another way of saying it.
It's very unusual. I've never seen, in my 28 years of practice, I've never seen a prosecutor take the stand.
I have. I have seen a prosecutor take the stand. Not personally. It wasn't in one of my cases. It was in another case. And I can tell you, when the prosecutor made the decision to take the stand, every defense lawyer in the province, I think, knew about it within a few hours. Within a few hours, I think we knew about it, because everybody talked about it. And ultimately, it didn't work out well for that prosecutor. It was a bad idea. I think Erlinda Johnson is entirely correct about the bad idea to take the stand. And I think that the reason why Carrie Morrissey took the stand was because she was trying to throw Hancock under the bus. Hancock is like, nah, if I'm under the bus, you're coming under the bus too. There's lots of room under the bus and you got a spot. And then Carrie Morrissey's like, I don't belong under the bus. I'm just going to say, bad decision for any prosecutor. If you can avoid taking the stand in any court case, if you have the option to avoid taking the stand, absolutely do not take the stand. The stand is a bad place. The stand is a terrible place to be. If you have the option to not be there, don't be there. The stand is like Detroit. Don't go.
Right. Erlinda, tell me, in terms of what should happen with Hannah Guitierrez, do you believe she should get a new trial now based on this non-disclosure of the evidence?
That one's a little bit different. As I think I was not involved in the Hannah Guitierrez trial at all. My understanding, which I learned on...
For the people who are saying I'm from Detroit, I am referencing a movie. There is a movie, I think it's... I'm trying to remember which movie it is that... I'm trying to remember. It is the Kentucky Fried movie. In the Kentucky Fried movie, there is a scene where they say, "Take him to Detroit," and the guy's like, "No, no." So that's why I use Detroit.
Thursday evening, Friday morning, is that Mr. Teskey was a defense witness for Hannah Guitierrez, and Ms. Gutierrez's counsel asked that those rounds be brought to court by Mr. Teskey.
Oh, this is interesting.
And then counsel for Ms. Gutierrez said he was not going to call Mr. Teskey and sent him.
They had Mr. Teskey on their witness list, and they brought him, and then they were like, "Oh yeah, we're not." I'm sorry, I wouldn't have put the rounds in my filing at all if I chose not to call Mr. Teskey. Sorry, you waived that shit. Nope.
And that's when Mr. Teskey apparently went to the sheriff's department.
I'm just gonna say their decision not to call him, and to then use Mr. Teskey in their application creates the very real possibility that the prosecution is going to, yes, Morrissey said that on the stand, but now we have confirmation of that. They're going to dunk on that in their response. They're absolutely going to dunk on that in their response.
Department, and surrender those rounds. But I understand that
Bowles, what are you doing? Like, this is so dumb.
There are other reasons that counsel for Ms. Gutierrez is moving to set her conviction aside. There was a disclosure of a third expert, firearms expert report that was not made available to the defense in that case. That is an issue that I believe has already been raised or will be raised.
It has already been raised. It was already raised.
As far as the rounds, it really depends on, because the defense in Gutierrez was aware. That's the difference between the Baldwin case and the Gutierrez case. In Baldwin, the defense was not given those, or given the report, given the opportunity to inspect those rounds. In Gutierrez, her counsel was aware of those rounds. In fact, it was his witness who brought them to court. My understanding was that he showed them to counsel, and then he was sent away. The witness was sent away. So that's a little bit, I think that she is in a little bit of a different posture as it relates to that evidence. There may be other evidence that may come into play.
Serve as a basis for that. Right. I know that Attorney Jason Bowles does have a few other things. He'll be on with us tomorrow morning, so we'll certainly ask him. Want to say a big thank you to you.
Wait, he went on to be interviewed? Okay, that's interesting.
Thank you, Erlinda Johnson, for being so transparent. And might I just say, you wouldn't know this because you were busy in the courtroom on Friday, but prior to all of this occurring and the big hearing, we had done a segment on you because we were so impressed with your advocacy and the lawyering that you displayed in the courtroom. I know.
Oh, okay. Okay.
You've got many years experience as a prosecutor and as a criminal defense attorney now, and it showed. And so I think what we've really learned is what a tremendous lawyer you are and also what an ethical one you are as well. So thank you for your time. Would love to speak again.
Oh, okay. This is this is like excessive fawning.
With you sometime.
Thank you.
All right, we're gonna cut that off here. This appears to be the end of the interview. That got a little bit like there's a point where it's just like, yeah. Okay. I see some people saying please cover bulls. I want to cover bulls. Here's the thing. And my voice is feeling a little bit better through the healing power of Scotch. Believe it or not, the Scotch actually helped my voice a lot. We're going to have to cover bulls on another occasion. I will probably do a video covering bulls. I'm not feeling 100%. I am not feeling fantastic. I am going to, I think, wrap it up here. And we will cover bulls another time. It can, So, yeah, we will, we'll see. We are going to go through the super chats. Daisy M, thank you so much for the YouTube membership. Much appreciated. Kyle Fox, I 100% think Carrie Morrissey put this out there because she was pissed the police slipped up on this. That is my theory. I can't say it's certain. I can't say it's 100%, but that is my theory. Claude Simeon, are actors never pointing directly at each other for gun standoffs, duels on screen, or does it vary by movie or set? It varies, but the thing is that the standards for like what sort of precautions you're going to take are different based on what you're doing. If you have two people pointing a gun right at each other's heads, you are going to have different standards for how you do that shot than if you have two people who are pointing the gun at each other's heads, but it's cheated angles so that you can't tell that they're not actually pointing at each other. Sometimes in movie scenes, you will have somebody pointing a gun directly at their own head. And I can tell you there's different safety standards for that than if they're pointing the gun at a watermelon, right? Because if the watermelon dies, nobody mourns the watermelon. The watermelon doesn't have a wife. It doesn't have kids. It doesn't have an estate that's going to sue the shit out of you. All sorts of different reasons. So, yep. Automata, thank you for the super sticker. Much appreciated. Why did they use special prosecutors in this case? Because prosecutor's office was overwhelmed. So, yep. Vomit Fountain, I would love to see Erlinda interviewed by someone more competent. I would love to interview Erlinda. I would love to talk to her. She is wonderful. But, yeah, I didn't like those interviews. I mean, I'm nitpicking. It is what it is. Kimberly Stovall, Como is asking questions for the dumbest among his audience. He's really a smart dude. That may be true. I may not be giving him enough credit. Rainman YYC, thank you for the 10 gifted memberships. Much appreciated. Snakes Will Hiss, thank you for the gifted membership. I love the username, by the way. Claude Simeon, Obsequious Fawning Super Chat, thank you so much. Black Wingy, thanks. Thank you for the thanks. Much appreciated. I saw this one in the chat. Runkle, have you ever heard of even a single case where the prosecutor took the stand and ended up looking like the hero? Or is it a bad move 100% of the time? I haven't ever heard of it working out. So I haven't ever heard of it working out well. All right. So I am going to go and try to rest up a bit and recover. I will probably cover some of the Karen Reed stuff tomorrow. I'm also going to go and talk to Mrs. Runkle about, apparently it's Prime Day today. I didn't realize that. So I'm going to ask if there's any sort of camping stuff or anything like that we have to pick up. So I'm going to go chat with Mrs. Runkle, plan for our future vacation, which is a ways out. So we got time for planning. Let's, before we go, have some puppies. I feel like we needed some puppies, and now I'm going to roll the outro, and I will see you guys soon, quite possibly tomorrow. So, good night, everybody.